goes.
No, I understand you have to have one, but it's going to go to the attorneys only.
Okay.
I'm trying to help you.
It's recording.
I know. I'm trying to help you make sure you're on.
Give me a moment.
See?
Mr. Garces, you are on, so if you can just wait until the judge starts court.
Yes, sir. Yes,
Thank
ma'am.
you.
Mr. Garces, I sent you an email to the last email that you gave me.
Yes, sir.
I need you to check it and sign it as soon as you can. The judge is going to want that today, okay?
Right now? All right.
But mute yourself right now, okay? All right.
Okay. I just checked.
None. Review and sign.
All right, ladies and gentlemen, I'm going to come call the docket in just a moment.
Yes, sir.
I am not in my usual place right now. I'm over in Jordanton. I do not have a second monitor here in Jordanton, so I'm going back to the old-fashioned way where I have to back and forth between screens. So I will not be able to see the docket. I mean, I'll not be able to see Zoom whenever I'm calling the docket or doing anything else where I have to be looking at a PDF. So please make sure if you need to get my attention about something that you let me know who you are that's speaking. I'm also going to direct everyone to keep their microphone muted whenever they're not actually speaking to me. Attorneys for announcements, and any attorneys, anyone who either doesn't have an attorney or your attorney isn't present, please make sure that I know that so that I can know that you're here. Give me just a moment. We've got more in the waiting room. All right, beginning with the Atascosa County criminal docket. State versus Eddie Sines.
John Lamberson, judge here for the defendant. Mr. Steins is currently in custody in Maverick County. I haven't been able to confer with him yet. If Maverick's bringing him over via Zoom, I'd appreciate the ability to confer with him.
Okay.
And Your Honor, this one is the state filed a amended motion. I don't believe, at least probation told me it hadn't been signed yet. The state is asking for a capias to be issued and a warrant, a new bond amount to be issued in this case.
Your Honor, it has a warrant. It has been issued for the MTR. I sent it to Maverick County to see if they would get it served.
Okay, absent extraordinary circumstances, I'm not going to issue a new capias and set a higher bond on an amended motion to revoke. I mean, if it's gone from a dirty UA to he's been charged with attempted capital murder, yeah, that might be a good reason to raise the bond. But if it's
Your Honor, that actually is the reason why the state asked for a higher capias to be issued.
Okay, all right. I'll let you and the attorney confer. Let's see, I'm going to make Norma the host. I'll ask her to make me the co-host so you can get with Norma about breakout rooms. And Okay, give me just a moment. I need to leave the meeting and come back in. Norma, you're the host now. I should be in the waiting room in just a moment. All right, that's better. For reasons known only to it, Zoom has taken to telling me that I cannot minimize Zoom because the meeting is being recorded. I don't know why it says that. It didn't start that until Monday, but I found that if I leave the meeting and then come back in, then I can minimize Zoom. And I have to be able to do that when I only have one monitor. All right, State versus Jacob Rowinski. Mr. Adams? Says bench warrant. Is he in custody?
Judge, that the defendant, I just got a call from Captain Miller at the jail. He was supposed to be benched and we had a plea scheduled for today. And literally last night, they moved him from one TDC unit to the other without informing us. And so they weren't able to get him. He's in a different part of the state. And so we need to get a reset for that, Judge.
Okay, if you'll get with Norma on that, I'd appreciate it. Victor Hernandez. Says reset from 12/7. Does he have an attorney?
Yes, sir. Macario Hernandez.
All right, Mr. Hernandez. And is your client here?
I think
Victor Hernandez.
No, not you, Dan.
No, on Victor Hernandez, I went to interview him on the 18th when he was in custody, and he said he was going to retain.
Okay, does he have an attorney, or is he still is he in custody?
No, sir, he's not in custody.
All right, no show, I'll recall. Stephen Seiler.
Judge Richard Briggs for the defendant. Mr. Seiler is in custody, and we need to confer on that.
Okay, I'll mark you conferring, and as long as it's one, you don't have to announce anymore. Like I said, I've got this fixed where I can minimize Zoom now, and it pops the box up and says who's talking. Thank you, though. Juan Chapa.
Good morning, Your Honor. Mr. Chapa is in custody, and the defense would like to request a competency trial in this case.
Has he been evaluated?
He was evaluated. However, we would request a jury trial to determine his competency.
All right, get it filed.
Yes, Your Honor.
Same fellow on both cases. He's a junior on one.
Yes, Your Honor.
Okay. Jesus Arvijo.
Your Honor, that is a contested. Jesus or Julio?
Jesus.
Jesus, sorry, Your Honor. That is an MTR. I have spoken with the state. We do have an offer. I think we're just ironing out some of the details. We should get.
Is your client here? I just, right now, I'm just taking a call in custody. Okay. Jose Jacinto.
I'm present for him, Your Honor. He's in custody.
All right. And it says Saul Acevedo. Is that an old representation? Are you with that?
No, he has two cases, and I'm Saul's on the higher level offense. I'm on the newer case.
All right. Jenny Guerrero. Jenny Guerrero, Ms. Harkins.
Ms. Harkins is announcing in another court, and she said she'll be here momentarily.
Okay.
He's in custody, Judge.
Juan Garces.
He's logged on, Judge. I'm working on trying to get a waiver of arraignment signed.
Thank you. Jesus Arvijo.
In custody, Your Honor. That's a contested MTR for today.
Jose Jacinto. Same announcement.
Judge, I'm here on that, Judge.
All right. Well, actually, I think it's the other way around. That's Ms. Voigt's case, but I'll mark it. Y'all are both here, and he's in custody.
Yes, that's true.
All right. Edwin Martinez.
Not sure where he is, Judge. Haven't been able to reach him since last time.
Okay, no show. Cassidy Matula.
That's Ms.
I'm
Harkins.
here.
I'll mark you present. Wait for
Yes.
Ms. Harkins. Joey Swarthout.
I am present for him, Your Honor, and
I'm present,
he's
Your Honor.
on.
Mark you conferring. Dylan Dees.
I'm here, Your Honor.
Judge, we're here. Mr. Barrera is announcing in another court, but he'll be late, and we just need a reset on Mr. Dees this morning.
Okay, what's going on with this case?
I believe we'll be conferring with the prosecutor in it.
All right, I'll just mark you conferring.
Thank you, Judge.
All right, Juan Garces again, said he was present.
Yes, sir.
Macario Hernandez Jr.
Good morning, Your Honor. This is Doug Daniel. Mr. Hernandez should be in. We are not prepared to resolve that matter, Judge. We just got hired in October, and we're still working on the case. We're asking for a reset this morning.
All right. And get with the state on that. If y'all can work out dates, fine. If you
If we can get a date, can I just put it on the chat to you?
If you get that worked out with the state, yes, and with Norma, that's great. If I need to resolve an issue, let me know.
Very well, Your Honor.
1-2.
Your Honor, I'm here on that. He is in custody. We're gonna need a trial setting on that.
All right. Charles Bullard.
I'm here for him, Your Honor. He's in custody.
Troy Garcia. Troy Garcia, Ms. Carrillo, I think I saw her.
Yes, I'm here for him, Your Honor. He should have been logged on, but I'll inform the court when I find. I'm going to go find him.
All right. No show on recall. Israel Garcia. Mr. Flores online.
I'm here, Judge. I'll confer with the state on it, Judge, but I believe we're going to need a trial on that.
All right. Is your client in custody or here?
He is in custody, Your Honor.
Okay. Jacob White.
Your Honor, this is Bobby Maldonado from Mr. Light. We have an approved waiver of arraignment order setting case for trial. It was signed by Judge Ellison. I just wanted to inform the court of that. It was just accepted and received this morning.
Okay, remain on docket. You're excused if that's all you had.
Thank you, Your Honor.
Christopher Street.
Your Honor, I'm here on that. I don't know if he has been bench warranted yet. He was in custody in the Dallas area somewhere. Maybe district clerk. You have any information?
All right, we'll check on him. Robert Navarro Jr.
He's in custody, Judge. I'd like to reset that to 217. It's a case that I need to talk to him in person about, and this week I haven't been able to.
Okay. Ashton Garcia.
Your Honor, he's in custody right now, and I will have your to you this morning, Your Honor.
All right, thank you. Marcelino Esparza. Marcelino Esparza.
He's in custody.
Yeah, he's in custody and he has a waiver. Ms. Harkins filed a waiver of arraignment, Judge. It's in the queue for 217.
Jennifer Aguilar.
I'm present for her, Your Honor. I've not had contact with her since she got out.
All right. Jennifer Aguilar. No show. I'll recall. Katie Creech.
She is present at the probation department, Your Honor.
I'm here as well, Your Honor, and I believe we're going to have a plea today.
All right. Hey, Jesse Garcia. Scabanas. All right. No show. I'll recall. John Garza.
Your Honor, I'm here for him. I thought that I saw him online. He signed a waiver. I signed a waiver. We submitted it to the coordinator for 2/17/2021.
217. Kim Hinkle.
Good morning, Your Honor. Counsel's present. She should be in my office within the next couple of minutes.
All right. No show. I'll recall. James Jordan.
I'm here for him, Your Honor. I've had no contact with him either.
All right, James Jordan, no show. Luna. Torres,
What was that, Your Honor?
Lori Luna,
Oh, she's in custody, Judge.
Wade Mahan.
Good morning, Your Honor. I believe that my client's online as well. We have both signed and submitted a waiver. I was told yesterday that it was approved for February 17th.
Because your video is stopped.
Okay.
Okay. All right, you're excused. Thank you.
Thank you, Your Honor.
Thank you.
William Alvarado,
Present for him, Your Honor. He's in custody.
Anthony Carrasco,
Morning, Your Honor. We have a waiver of arraignment on file. I have not been able to see him on the Zoom yet.
okay, but you've already submitted the waiver?
We have, Judge.
And when is it for?
Judge, let me check on that. I'm sorry.
It's
Let me
for
get it.
217.
Okay, that's when the rest were. Thank you. He's fine. Carlos.
Okay, thank you.
Your Honor, was
Carlos,
that Carlos Flores?
with a K, yes.
Eric DeWalt, I represent Mr. Carlos Flores. He is on the Zoom right now. I tendered a waiver of arraignment. I believe there was one sent back in agreement for 217.
Okay, if that's all you have, you're excused.
Thank you very much, Judge.
Roseanne Gomez.
I am here on that, Your Honor. I'm not sure whether she's in custody or not. I just got the appointment, essentially. So.
Okay, no show.
I don't, yeah.
We'll have him check. George Gonzalez.
He's in federal custody, Judge.
Okay. And is that case going to be dispositive, or is he going to have to come back here, you think?
I don't know. That's what I'm trying to confirm with
That's
Mr. Lam
actually
at the moment.
the rest of the state.
I'll check on that, Judge.
Carlos Herrera Jr. Mr. Shaughnessy.
Present, sir.
Judge, he filed a
Hello?
waiver of arraignment for 217 on that case.
Okay, that's fine. And who's the phone number with a 661 area code?
Yes, sir. It's not my phone number. I forgot my phone at home.
Okay, what's your name?
My name is Carlos Herrera Jr.
Give me just a moment. All right, I'll mark you present. And that's 217, you said? Waiver?
Yes, Judge. Yes,
All
Judge.
right, Mr. Herrera, you already have a court date for 217. You're released. Colton Mann.
He's present, Your Honor. He's a recent appointment, so we'll talk and get that waiver on file shortly. We excuse me, we do have one for 217, and we'll also confer.
Abel Martinez.
Morning, Judge. Robert Gear here. Abel should be here. We filled out and filed a waiver for a pretrial date of February 17th.
Okay, that's fine.
Yes, sir. I'm here.
All right, you're excused.
All right. Thank you.
Will Jonathan Moore.
Same announcement, Judge. This is an arraignment. We filled out and he filed a waiver of arraignment for Mr. Moore.
Okay. Eddie Ortiz.
Judge, I'm Edward Adams for Eddie Matthew Ortiz. I don't know if he's on or not. Mr. Ortiz, are you present?
All right, no show. I'll recall. Connie Rodriguez.
I spoke with her mother this morning. She's supposed to be in court.
She is present at the probation department, Your Honor.
All right, I'll mark.
Judge, today was the first day I got in contact with anybody, so I have not gotten her to sign a waiver of arraignment.
Okay, well, you can get a breakout room from Norma and talk with her in probation. Joe Rodriguez.
Here, Your Honor. He's on the phone, Judge, and the same thing. I got a hold of him this morning, and I haven't gotten him to sign it.
I'm here, Your Honor.
Okay, Mr. Rodriguez, I've marked you present. Thank you.
All right.
All right, Mr. Flores, okay, then we need to get dates, including a date to monitor a waiver of arraignment if you get 217. Michael Rogiers. Michael Rogiers.
A waiver of arraignment has been signed, Your Honor, for 217.
All right, thank you. Porfirio Santos.
Morning, Judge. Mr. Santos is present. He has signed and we have e-filed a waiver for February 17th.
Okay, and who is his attorney, you or Mr. Finkel?
I've been retained, Judge. And we filed an appearance at counsel and forwarded that over to Mr. Finkel's office as well.
Okay, I will make that notation. Crystal Cepeda.
Yeah, good morning, Your Honor. I'm present for her. I have not had any contact with her since she was released.
All right, Crystal Cepeda. No show, I'll recall.
Thank you.
Frederick Sullivan. Mr. Gear.
Morning, Judge. We've had no contact with Mr. Sullivan. We tried to get a waiver to him. However, all the contact information on his appointment form is incorrect. The number's not working. So we've had no contact or communication with him.
I'm
Okay,
showing custody.
Oh, custody where?
Here in Atascosa.
Okay, excellent. I'll mark him in custody. Jessica Wessels.
Your Honor, I was present. Oh, there we go. I was appointed to this case back in April. I hadn't had contact, so good to know you're on here. I'll speak with her after this, Your Honor.
Okay, did she answer?
Yes, The Bridge, I believe, is the name of the phone she called from.
Excellent. Okay, I will mark you conferring. Criminal ad, State versus Jose Garza.
Defendant should be in custody, Your Honor.
All right, Mr. Briggs.
Yes, Judge. He's in custody. This is the plea that we started on Monday and then reset for today because we were discussing his back time. We'll I'll need a breakout room with him after the docket.
Jesse Coronado.
Good morning, Judge. I believe that's set for a plea this morning, and he's in custody.
Roger Talamantes Jr.
Judge, I'm present for him. We have paperwork. I just got to get it breakout room so we can get it signed, and we'll go forward with the plea.
Okay, is he in custody?
He's in custody, yes.
All right, Julio Araujo III.
That's the same announcement from earlier, Your Honor. He had the MTR. He's in custody.
Mr. Coronado is in custody. Give me a moment. Crystal Ferdine.
Judge, that also was a plea we reset from Monday. She should be in probation.
She's not here, Your Honor.
I'll check on her, Judge.
I'll recall, no show. All right. Manuel Gaitan.
John Lamberson here for the defendant, Judge. He's in custody. We just need to confer, then we'll be able to get a waiver of arraignment on file with the court.
Okay, so PDO in custody. All right, now let me get back to Zoom. Okay, is there anyone else who was told to be here today that your case was not called on a criminal case only? Just on criminal cases.
Judge, I believe we have Jesus Flores who is set this morning for a bond hearing.
He'll be on the civil ads. Technically, writ is a civil case. Okay.
Thank you, Judge.
I'm trying to look through the screens. I've got 3 screens here. Is there anyone waving their hands or anything? Is there muted? All right.
No, I'm just waiting for Megan Harkins.
Okay, she's online. All right, I'll let the attorneys for the state and any attorneys with no civil matters in the docket be excused. Let's see who's in the waiting room. Stephen Barrera and a phone.
Your Honor,
Yes.
my client says is Troy Garcia. He's on page 3, I believe. He says he's online, Your Honor.
Okay, under what name?
I don't see him under his name, so he must be under Troy. If you can hear this, announce yourself. There he is.
On my iPhone, I'm present.
Okay, I'll rename that.
Okay.
It's Troy what?
Garcia.
Garcia.
And Your Honor, if I may make an announcement as well, my client Kim Henkel is here.
Yes. And this is going to be, my case is going to be a trial case, Your Honor, so we'll ask for the next date.
Okay. All right. Mr. Arguelles, by here, do you mean in your office?
Yes, Judge, I can show. That is her right there.
I believe you. I just want to know what you're saying. All right. And I tried to rename the phone number with a 661 area code and it didn't work. Ask that person again to unmute. What's your name?
This is Carlos Herrera Jr., sir.
All right. Thank you. And it worked that time. I'm going to mute you. Have any other phone numbers? Okay, there's an area code 210 phone that ends in 395. Who is that? Asking you to unmute. Okay, they left. There's a phone number that 210 area code that ends in 158. I'm asking that phone to unmute. All right, nobody wants to talk. Again, I'll release the attorneys for the state, any attorneys with no civil matters in the docket.
Hello?
Yes, what is your name?
Jennifer Aguilar.
Okay.
Jennifer Aguilar?
Yes, sir.
All right. Who is your attorney?
It's me, Your Honor.
Ms. White. Okay, I'll mark her present. All right, on the civil dockets. I'm calling the civil. Oh, I have just the ads. All right. State, it's In re Jesus Flores.
Good morning, Your Honor. Counsel's present. Mr. Flores is in custody. This is a writ of habeas for a bond reduction. If I could have just an opportunity to confer with Mr. Thornton before we make our announcement.
Absolutely. There's Norma's doing the breakout rooms.
Thank you, Judge.
All right, let me look here. Today's the 16th, I think. Yes, I have just the civil editions. Excellent. All right. So I haven't seen heard anyone getting breakout rooms. Please get those going.
They are done. They are done, Your Honor.
All right, excellent. All right. I mean, they need to let you know so they can start moving to them. And whatever pleas we have today, I'm going to direct the attorneys and the clerk and whoever else needs to confer. And I want to make sure that before the plea packages are sent to me, that they are complete. That means they're signed and the state's attachments are there. And if it's a plea and not an MTR or a motion to adjudicate, make sure that a copy of the indictment is there so that I know what the individual is charged with and I can caution them about that. So I'm going to start going through my emails and I will be here when we have something for me to move forward with. Let me know.
Your Honor, may I make an announcement on one of my cases that I missed?
Yes.
Okay, on page 3, Cassidy Matula.
Yes.
She is present. We have an agreement with Mr. Lamb, but we are waiting on the county attorney's office to, for us to work out a DWI. That is set for mid-January, so we'd like to get a new date on this to late January to resolve it.
All right, that's fine. Just get that from Norma at the coordinator's office.
Yes, Your Honor, thank you.
Megan, I believe there's a date for January 27th.
Okay, great, thank you, Kenny.
Judge, if I could make an announcement, I got the waiver of arraignment for Juan Garces. It's signed. I just e-filed it. I was hoping that after I post that in chat, I could be excused. Edwin Martinez, I tried calling him. I can't get a hold of him.
Okay. Was Garces on the add-ons?
No, he's on the main page, sir. 2116 and 27200.
Spelling Garces with the C, that would do it. Okay, so that's for 217?
217, yes, sir.
And you are excused, thank you.
Thank you, sir.
Garces also.
Your Honor, I have an announcement as well.
Yes.
My client's name is Jesse Garcia. He's in custody.
Okay.
I have not filed the waiver of arraignment, Judge. However, I will be going to the jail to get a signature today, so I will submit it to the court before 5 p.m. today.
All right, Jesse Albert Garcia?
Yes, Your Honor.
Okay. Give me just a moment to look at the calendar. And what date is that for?
I believe it'll be February 17th, Judge.
Okay, I'm going to set it for 113 to modify the waiver.
Yes, Your Honor.
And 217 for pretrials, as long as the waiver has been completed and you don't have to be here. He doesn't have to be here, he's released on 113.
Yes, Your Honor.
All right.
Thank you, Judge.
Yes.
Judge Wilson.
Yes.
I have a jail case also, Jacinto, the last name.
Okay.
That's a case where Lisa Voigt has one of the cases.
Yes. Yes, so she made that announcement. So yes, he's present. He's in custody. And I've marked you and the state and Ms. Voigt concurring.
So can you put me in a breakout room with Mr. Lamb?
I cannot because Norma is in charge of the breakout rooms today. I made her the host.
Okay.
The three of y'all, you and Ms. Voigt, need to get together with Mr. Lamb. There may be a line to speak with him.
Judge, this is James Anders for Jacob Garza. Can he be excused? We've got a waiver on file that we sent to the coordinator for the 217 date.
Okay, hold on a second. And your client was James who?
Jacob Garza.
Jacob.
He's on page 6.
All right, hold on. I do the search. Yes, I already have him down for 217.
Okay, thank you, Judge. I just wanted to make sure. Thank you.
Okay. All right, anything else? Okay, let me know when y'all have something ready. I'm going to start working on emails and the judge's docket. Judge's part of e-file.
Norma, can I get a breakout room with Mr. Barrera?
Okay, Norma's doing
Yes,
breakout
sir.
rooms.
And Norma, could you join me into breakout room number 2 with Mino and Kenny?
Yes, sir. Mr. Lamerson, you just need Mr. Gaitan, who's in custody?
Yes, ma'am. And also Eddie Signs, if Mr. Signs is in one of the breakout rooms. I was just chatted by Kenny asking if I could join him and Minu in breakout room 2.
Are you sure
Okay,
Spencer's
yes,
set
sir.
today?
I sent you the 2, Mr. Lamerson.
Hey, Norma, can I ask you a technical question?
Yes, ma'am. Minu.
Norma?
Yes.
Norma, I put in the chat a request for court date for Troy. It's a trial case, so.
Okay, we don't have any trial dates, so what we're doing is moving them to the 217
217?
pre-trial docket. Yes,
Okay.
ma'am.
217.
Thank you.
Thank
Uh-huh.
you.
Yes, ma'am.
Do I have to wait till the judge comes back on, or is the judge on?
No, if you'll go ahead and post it to chat with the name, cause number, and the date, then you're excused.
And my client is too, right?
That is correct. Yes, ma'am.
Thank you.
Uh-huh.
Norma,
Yes.
this is Saul Acevedo on
Yes.
Jacinto. I just chatted with Mr. Lamb, and
Yes, sir.
there's nothing new on my case. The plea bargain is still the same. Can I be excused?
If you'll post to chat with the name, defendant's name, cause number, and date of 217, post to chat, and then you're excused.
217?
Yes,
Okay.
sir.
If that's cause number, name, and then date.
Did you hear that, Lisa?
I did.
Hi, Norma. Is the district clerk on? I just need to verify where Mr. Street is, Christopher Street.
They should be on. Yes, sir.
No.
Yes, I'm here.
Oh, I'm sorry. Yeah, Christopher Street. Is he still in custody? He was in, I want to say somewhere up in Dallas. Montgomery County comes to mind, but I'm not 100%
I
sure.
don't, if he's in somewhere out of county, I don't know, sir.
Okay. All right, thanks.
Norma, could you please add Brittany Ibarra to the breakout room number 2?
Yes, sir.
Thank you.
Judge, I didn't judge
Ah,
this.
he got off. I don't see him anymore. All right, I gotta go to the next one.
Judge, this is James Anders. I have a question. Yeah, so as far as the pleas, Are you going to go back through the docket and attempt to take them one at a time, or when you get the paperwork from Norma, then you will call out the name? What is the plan to?
Whatever will be most expeditious. I mean, if somebody's conferring with three folks, it doesn't make much sense to have them, like the state's attorney, have them stop doing that so we can come take a plea, because I'm going to have to wait either now or wait later.
Right.
Whatever is most expeditious, I'll do. Whenever the police papers start getting finished, make sure the packages are complete to me, and we'll get started as soon as we can.
Yes, sir. Miss Norma, how would you like us to verify with you that the plea packet is complete?
Hey, Mr. Andrews, just look it over. No, we're not gonna have the clerk or the coordinator or anybody checking the attorney's work. You ought to be able to look at it and say, is it signed? Are the state's attachment attached? Is there a copy of the indictment? Or just the state's attachment if it's an MTR or an MTA. We're not gonna daisy chain that back through some third party.
Yes, Your Honor.
Excuse me, Judge. If I just file Miss Henkel's waiver of arraignment and got all the recent dates for my clients that are in custody, may I be excused, Judge?
Yes.
Thank you.
Mr. Anders,
Yes, ma'am.
it's Chris at the district clerk's office. You said you filed a waiver of arraignment for Jacob Garza?
I sent it to the coordinators. If you'd like, I can file it.
Yeah, you're supposed to e-file it.
Okay, my apologies.
Okay, that's okay. Thank you, sir.
Norma, I'm available for Mr. Acevedo and Miss Voigt if you want to just put them in breakout room 2.
Yes, sir.
Hello?
Yes, Mr. Herrera.
Oh, okay. I was just making sure I was still on because it got really quiet.
You're on. Your attorney will be with you.
Judge, for him, he's the one that has a waiver of arraignment already for 217.
Okay, then you're released, sir. Thank you.
Thank you, sir. Thank you, sir.
Norma, did Mr. Acevedo
He
leave the
logged off.
meeting? He
He did
logged
leave
off?
the meeting. Yes, sir.
Okay, did he post a new date? Because I know that I had left at one point.
He just put the name and the cause number, no date. And he logged off.
Okay.
I think he had just discussed with Ms. Voigt whatever date she had, I guess, because they both have the same guy.
Oh, okay. I'll get back in the breakout room with Ms. White then. Thank you.
Thank you.
Actually, Norma, can you put me briefly back in the breakout room with Atascos, the jail?
Yes, sir. Go back to breakout room number 1.
Jail, can you join me briefly?
And Norma, would it be possible for me to join the jail whenever Mr. Nitz is done as well?
Yes, sir.
Thank you.
Uh-huh.
All right, Norma, can I speak with Brad or Kenny if they're
Yes,
available?
sir. I'll give you a breakout room.
I think it's Brad that's doing this.
Okay. Mr. Arguelles, if you'll go to breakout room number 7. Mr. Dawes, if you'll join breakout room number 2.
Judge, are you available?
Yes.
Just very quickly, I told John on our one arraignment case to do the waiver like I did yesterday for you. Are you okay with that?
That's fine.
Thank you.
Sure.
Your Honor, Jason Nitz for Roger Telemontes. I'd like to request another reset. The state is in an agreement. There's another misdemeanor that if he agrees to this, he'll be shipped out and I won't be able to deal with. I've been in
But
contact.
that's fine. Just send that in chat and I'll get it written down.
All right, thank you.
And I've got to take a break. I'll be back in about 5 minutes.
Norma, it's Lisa Voigt.
Yes.
Is my client Jennifer Aguilar still there?
I don't see her on the screen.
All right, she called in late. And I needed to.
She's on the screen. Is it
Okay,
a phone number?
I need that phone number, please.
It doesn't show phone numbers.
Okay. Can you send me to a breakout room with her, please?
Yes, I'll get you to one.
Thank you. And then I posted all my other cases.
Yes, I saw that. Thank you.
The only one I didn't post is the one where the client didn't show up. And that was James Jordan.
Norma, I've got a waiver signed by my client, Miss Jessica Wessels. I'm going to file it right now. I've got the new date for her. I wanted to see if I could get her out of here while I file the waiver.
That date has a 2/17 date on there?
Yes, ma'am.
Okay, yes, sir. If you'll just go ahead and post the chat, please.
I already did, and I'm filing the waiver right now. Thank you.
Okay, very good. Thank you.
Bye, Miss Wessels. I'll talk to you soon. Thank you for getting me that.
Norma, I have a Connie Rodriguez at probation. I was going to see if you can put me in a breakout room.
Yes, sir. I'll give you breakout room number 8.
Okay, we'll get her in there.
Jennifer Aguilar, are you online?
Norma, she's muted.
You know what the last 3 numbers you see, Chris? Is it 562?
No, it says Jennifer Aguilar. The judge changed her name.
Okay, thank you. Miss Voigt, join breakout room number 3 with Miss Aguilar.
All right, thank you.
Okay.
Norma, could you put me and Mr. Briggs in a breakout room or in breakout room 2?
Yes, sir.
Thank you.
Uh-huh.
Is the jail available?
Yes, sir.
Can we get Mr. Talamontes back?
Yes, sir.
And can I be put in a room with them, please?
I'll put you in a breakout room, Mr. Nitz.
Thank you. Oh, actually, what? Real quick, can I be put in with Bradley?
You need what, Mr. Nitz?
Real quick to be put in with Bradley before I go into the break.
Okay. Okay.
Are we still in?
Norma. Norma, can you hear me?
Hold on just a second, Ms. Boyd.
Okay.
Yes, ma'am. I'm sorry. Go ahead.
So my client is on mute and I don't know how to tell her to get off of mute other than screaming and hoping she can read my lips.
If she's on the phone, have her press *6.
How am I going to communicate that to her?
Oh shit. I don't know. Send her a
Because
chat.
I tried to do a chat to her, but
Uh-huh.
when I'm in a room, it won't let me chat to anyone but everyone. She has no idea.
It should be everyone in the room, so it should only be to her.
If I go ahead and do that,
I think so, but I mean,
it's not working. I mean, I can't communicate with her like this.
Let me see if I can join that room. Hold on.
All right, now I'm ready for the jail. Thank you.
Yes, sir.
Family violence or child division?
It's trial, it's drugs.
That's okay. Okay, it's gonna be Mr. Best. As soon as he comes out of breakout room, I'll put you in the mix.
Okay, thank you so much.
You're welcome.
Mr. Nitz, number 6.
Norma, has Michael Baird already left the room, left the chat?
Yes, sir. I don't see him in there. I don't even see him on the screen.
Okay. Do you know if he had got some reset dates?
I don't show any on my chat.
Okay.
Hello?
Yes, sir.
Yes, ma'am. I was having trouble getting on, and I finally got to check in, whatever.
Are you Mr. Carrasco?
Yes, ma'am.
Miss Harkins is your attorney?
Yes, ma'am.
Okay. She reset your case to 217.
217?
Yes, sir.
Okay. All
Yeah, if you
right.
yeah, and just make sure that you contact her and get in touch with her in reference to that, okay?
Okay, yeah, I'm sorry because I was trying to get on at 9 o'clock, and I don't know. I didn't know I didn't know how to mess with this thing. So, yeah. Then I called to the office, and her secretary showed me how to do it.
Okay. I mean, it's up to you if you want to wait. She's still on Zoom because she's got other stuff. If not, you can contact them and let them know that we told you that.
Okay, that's fine. Thank you.
Mm-hmm.
Bye.
Norma, can I get a breakout room with Brad? I see
Yes,
him right
sir.
now. He
Yes, sir.
doesn't appear to be doing anything.
Yes, sir.
Okay, thanks.
Norma, were you able to communicate with my client?
No, I don't see her on there. I'm trying to see if I can find her in any of the rooms or anything, but she's not available anywhere. I don't know if she logged off or not.
Okay, well, I posted her date for February, and I'll find her somewhere, somehow.
Yes, ma'am.
If she gets back on and is able to communicate with you, would you please tell her to get in touch with me?
Yes, ma'am, I will.
Okay, and I am going to leave now. Thank you.
Yes, ma'am.
All right. Have a plea packet on Creech. Let me look at that. Oh, go ahead.
And then click your video. Start video. Yeah. There you go. Can I think I need to sit up higher. You're fine. I can see you.
Norma,
Yes, sir.
can I get in line for a breakout room with the jail? I'm needing to talk to two people there.
Yes, sir. As soon as they come out of a breakout room.
Okay, thank you.
Thank you.
Okay, are we ready in State versus Katie Marie Creech?
State's ready.
Defense is ready, but I don't see my client yet.
Yes, Your Honor, she's there at the Atascosa CSCD.
Okay, my apologies. Oh, okay, yes, I see her now, yes.
All right, Ms. Creech, I'm going to ask you to remove your mask for the plea. Are you Katie Marie Creech?
Yes, sir.
Is that your true and correct name?
My last name is Bobel on my social.
Okay, but whatever your social security card says, you also go by Katie Marie Creech?
Yes.
Can you speak, read, and write the English language?
Yes, sir.
Are you a United States citizen?
Yes, sir.
Despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and denial of naturalization benefits. Do you still wish to enter a plea today?
Yes.
And Your Honor, before you proceed, I did not prepare a motion to proceed on lesser included, but we are proceeding on lesser included on both count 1 and 2. They're both going to be Class A misdemeanors. And so I just wanted to bring that to your attention.
Yes, Class A or one of them is Class B?
That's correct. It's a DWI, I believe the assault family violence, correct.
All right. Now, the waivers I've been given say that she's charged with a second degree and a state jail felony.
Yes, she's charged with aggravated assault and then intoxication assault, attempted intoxication assault. And so on that one, we're proceeding to a driving while intoxicated. And on the aggravated assault, we're proceeding with assault family violence.
All right. So is the caption of the indictment correct? Attempted intoxication assault is a state jail felony?
Yeah, well, that should be a state jail felony. Yes, yes, Your Honor.
All right, so that part of the indictment is just there's a conflict between the waivers and the indictment. All right. All right, ma'am, do you have any history of mental health problems or mental illness?
I have ADD, depression, anxiety, and I'm bipolar.
All right, have those issues kept you from being able to speak with your attorney, Mr. Anders?
No, I'm on medications for those.
Have you been able to understand what your attorney has told you about what your rights are and what your options are?
Yes, sir.
Have you been able to make him understand what it is you want to do in this case?
Yes, sir.
Okay. All right. Counsel, do you believe your client's competent to stand trial?
I believe she is, Your Honor.
All right, man, you stand charged by indictment right now. I know you have a plea bargain that would reduce these, but with second degree felony offense of aggravated assault with a deadly weapon and with a state jail felony offense of attempted intoxication assault with a vehicle causing serious bodily harm. Okay, with a vehicle rather. Account number 1, the aggravated assault with a deadly weapon alleges that on or about June 4th of this year here in Atascosa County, you intentionally, knowingly, or recklessly caused bodily injury to Dane Orion or Orion Creech, the complainant, by striking the complainant with a car, and that you did then and there use or exhibit a deadly weapon, a motor vehicle, during the commission of that assault. That alleges a second degree felony, which is punishable by confinement for not less than 2 and not more than 20 years, and by a fine not to exceed $10,000. Count number 2 alleges that you operated a motor vehicle in a public place while intoxicated, and by reason of that intoxication, you attempted to cause serious bodily injury to another, Dane Orion Creech, by accident or mistake. To wit, by intentionally striking Dane Creech with said motor vehicle. That alleges a state jail felony, which would be punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. Now, my understanding is that you have a plea bargain that would reduce count number 1 to a lesser included Class A misdemeanor of assault causing bodily injury, family violence. And that is punishable by confinement for not more than 1 year in a county jail, and by a fine not to exceed $4,000. So do you understand what the range of punishment is on, actually back up, on the felony cases that you're charged with, do you understand what the range of punishment is?
Yes, sir.
All right. And my understanding is the attempted intoxication assault is being reduced to a first degree or first offense, driving while intoxicated, and that is punishable by confinement in the county jail for not less than 72 hours and not more than 180 days, and by a fine and/or a fine not to exceed $2,000. So do you understand what the range of punishment is on the misdemeanors that you have a plea bargain agreement for?
Yes, sir.
Do you understand that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea?
Yes, sir.
You understand that if I do follow the plea bargain agreement you have, and the sentence I impose is not harder on you than what you have agreed to, you will not be able to appeal this matter?
Yes, sir.
All right, I want to show you some documents that appear to have your signature. They're titled Admonitions to the Defendant for Plea to the Court. And let me ask, paragraph 2.11, is this your signature?
Yes, sir.
And where it says verification, is this your signature?
Yes, sir.
And do you swear or affirm to me that everything above your signature on verification is true and correct?
Yes.
Okay, did you also sign on certificate of appeal,
Yes, sir.
agreed punishment recommendations,
Yes, sir.
waiver of preservation of evidence,
Yes, sir.
and the discovery compliance certificate?
Yes, sir.
Right. Did you read these documents yourself, or did Mr. Andrews read and explain them to you?
I read them.
Okay, did you understand these documents before you signed them?
Yeah, well, the questions that I did have, I asked my lawyer and he answered them for me before I signed. So I understood what I was signing.
Okay. And are you satisfied with the work that Mr. Andrews has done for you?
Yes.
And has anything happened since November the 20th to make you think that perhaps you had not understood what you were signing, or to make you want to take your signature back?
No, sir.
All right. Counsel, do you believe you received all the discovery you're entitled to in a timely manner?
I believe so, Your Honor.
And do you believe that your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
I believe she does, Your Honor.
All right. I will accept the discovery compliance certificate, and I'll find the defendant made her waivers of right and stipulations of evidence knowingly, intelligently, and voluntarily. And I will accept them. And I'm going to ask the state's attorney to read the plea bargain agreement into the record.
The plea bargain agreement, just a second, is on the assault family violence is a reduction to a Class A misdemeanor with a sentence of confinement for 1 year, probated by 2 years of community supervision, and a fine of $1,000. There's a 90-day driver's license suspension, anger management, court costs, of $315, Crime Stopper fee, $50, drug test fee of $50, standard DWI conditions, education, drug, alcohol evaluation, EMS trauma fee of $100, family violence fee of $100, requirement for the ignition interlock for the course of the probation, parenting classes, monthly probation fee. The PSI fees waived because my understanding is they're waiving the PSI, and then the victim impact panel. That's also included with the plea to count 2, which is driving while intoxicated class B misdemeanor. I noticed that the plea packet says confinement for 1 year, but the max on that is 180 days. So it would be for 180 days, probated for 2 years of community supervision.
All right, ma'am, you heard what was read into the record by the state's attorney. Is that your agreement with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
It sounded like something was taken out, but I understand.
Well, no, I need to make sure that that was your agreement. So do you need a breakout room with your attorney?
I agree with that.
Okay, so do you need a breakout room with your attorney to discuss whatever it is you thought should have been in there?
I guess that's up to him.
Is there, if there's something that you think is missing, then you and I can talk about it. If there's something you think is not missing, then we can continue on.
No, we can continue on.
So that is your plea bargain with the state?
Yes, sir.
All right then. So on count number 1, to the lesser included Class A misdemeanor of assault causing bodily injury, family violence, do you plead guilty or not guilty?
No contest.
All right. And count number 2, the first degree offense, driving while intoxicated, what is your plea?
No contest.
All right. And you understand, ma'am, that pleading no contest might be different than pleading guilty if you got into a civil lawsuit over what you were doing earlier this year here in Atascosa County, but that for all purposes inside this criminal case, pleading no contest is the same as guilty.
Excuse me? I missed the last part. I'm sorry.
For all purpose, in a civil case, if you come in here today and you plead no contest, and then you wind up in a civil lawsuit over what you were doing on the day in question, then in that civil lawsuit, it might make a difference that your plea today was no contest and not guilty. But that for all purposes inside this criminal case, pleading no contest is the same as pleading guilty?
Yes, sir. I understand.
Has anyone promised you anything other than your plea bargain with the state to get you to plead no contest?
No, sir.
Has anyone harmed or threatened you or anyone close to you for your plea?
No, sir.
Has anyone promised you an early release from your sentence?
No, sir.
All right. I'll find that you made your pleas voluntarily, not any compulsion in making them, and that's what evidence the state has.
State offers Exhibit 1 and it's Attachment A.
And we have no objection, Your Honor.
All right, without objection, State's Exhibit 1 and Attachment A are admitted into evidence. Do both sides rest and close at this stage?
State does.
Defense does as well, Your Honor.
All right, I've reviewed the State's Exhibit earlier. I'll find there is enough evidence to substantiate the defendant's guilt on both sides, on both counts. Are both sides ready for sentencing?
State's ready.
Your Honor.
Okay. And there's no pre-sentence investigation?
No, Your Honor. We'll waive that.
Okay. I guess what I want to know is what is going on with the defendant and her use of alcohol?
Your Honor, at one point in time, she did, several years back, she did have an issue with alcohol. She has sought treatment for that. She is currently under medication for that. And it's part and parcel with her, the other ailments that she listed earlier.
Am I allowed to add?
Yes, ma'am. Add anything you want.
I usually have alarms on my phone to take my medications. And during that time when that accident happened, I forgot to set my alarms on a new phone I purchased. So I was off of them for about 3 days. So that was a lot of the issue with that. But I am currently on my medications again. So.
And Your Honor, I believe that most of this, she was in a contentious relationship, and at this point in time, she is in the process of becoming free from that contentious relationship.
Okay. And does Ms. Creech have any other criminal history?
No, sir.
All right.
I'll double check my records, Your Honor, but I don't recall that there was anything. No, Your Honor.
All right, then. I will follow the plea bargain in this case. I tell you, I'm concerned about it. I'm not sure that the state could proceed on the second count the way it was charged. The first count looked to be a very righteous charge. What I say on most of the time whenever I talk to the attorneys is that there's folks that society is mad at and folks society is afraid of. And ma'am, if you're out there drinking and driving, society has a reason to be afraid of you. But if you're not, then it sounds like you're a great citizen. And that's what I always want going forward. So I will follow the plea bargain agreement in this case. I will find you guilty of a Class A assault, family violence, and also of driving while intoxicated first offense. And I will sentence you to 1 year's confinement on the first count, to 6 months confinement on the second count, both probated for 2 years with all the rest of the terms and conditions of your plea bargain agreement with the state. And do you have any children you have a duty to support or living with you?
Yes, I have a daughter.
Okay. And do you live in Atascosa County still?
Yes, sir. I live in Pleasanton.
All right, then you'll be reporting in Atascosa County to a probation officer. I'll tell you, I'm not saying that it's not important to do everything you're supposed to do on probation. It is, but if doing everything you're supposed to be doing except making your full payments on time, we will work with you on that. We will let you make larger payments towards the end of the 2 years. And I think on a misdemeanor, it could be extended to up to the 3rd year. Is that correct?
I believe that's correct, Your Honor.
That's correct.
So if absolutely necessary, we could even extend your period of probation to give you more time to make the payments. So I want to make certain that water pump blows up or something, and you can't make a payment 1 month, that you don't fail to go and see your probation officer just because you don't want to tell them you don't have the money. Okay, ma'am, so you understand that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you have no right to appeal?
Yes, sir.
Okay, I will find that you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. And I will certify to the Court of Appeals that you have waived the right to appeal and may not appeal. I wish you good luck.
Okay, thank you.
All right, and Mr. Flores, Ruben Flores, you sent me a waiver and it will not open. It doesn't say that it's corrupted. I just click on it and nothing ever happens. So if you could resend that, I'd appreciate it.
Yes, sir, I'll try.
Okay, do we have any other pleas ready to go?
Not that I know of, Your Honor. What I wanted to bring up on the Julio Arguello hearing we're supposed to be having with Mr. Lambert. We had discussed on Monday that would be this afternoon.
Right.
Can we plan on 1 o'clock for that so we can tell our witnesses the time to show up, or would that be okay with the court?
Let's make it 2 o'clock because we have a function going on here at the coordinator's office.
2 o'clock. Fair enough.
That's why I'm over in Atascosa County, not in Floresville.
Okay.
All right, Mr. Lemerson, I have signed the waiver on Mr. Gaitan. I will send that to the coordinator, pardon me, to the clerk in chat in just a moment. All right, Mr. Flores, what format are you sending me that document in?
Judge, I'm not sure. She was at probation and I got probation. I sent them the waiver through chat. And when the probation officer sent it back to me, it came back in this format. So I'm trying to fix it.
Yeah, it will not open. I've done it, downloaded it twice. It's there, but whatever it is, either the extension is wrong, and I need to know what the extension is so I can change it, or it's some funky format. I have anything that opens.
Yeah, I don't know. I was trying to change the format myself and send it back to you, but it's not working. So
Judge, I can try to send it back to you. It was a PDF.
All right, well, let me just change the name to PDF and see if that does it. Works fine. Okay, it's just the name got corrupted. Okay, and I've sent that to the clerk's office.
Judge, may I be excused on that one?
Yes, sir.
And I also have another one, a Joe Luis Rodriguez. He sent me an email with signing the waiver, but I think it's a picture, so I don't know if it's going to work for e-filing purposes. I was going to see if you could give me a monitoring date on the arraignment.
All right, can you just convert that into a PDF?
I'm trying to, Judge, yes.
Okay,
And
that's weird. Okay, and I just posted the Creech judgments. We have other pleas in the works.
Yes, Your Honor, I believe Mr. Briggs is still talking to his client in the jail.
All right.
So that should be a plea.
We also had for Mr. Barrera, Judge, but the verification, the defendant forgot to sign it, so I sent that paperwork back.
Thank you.
Your Honor, he's in custody, so it may take me a little bit of time to get him to sign that. Is there any way I can just move that to another date then?
Sure.
And then, Your Honor, we just have that contested hearing. I think we're going to do that after lunch.
Yes, I think 2 o'clock we've said.
2 o'clock? Okay. I do have, can I contact my witnesses and let them know? I think that's all I have. If we do have a time, that's perfect.
Yes.
2 o'clock. Thank you, Your Honor.
We also have a bond hearing with Mr. Rivera too on, well, I guess a writ.
Yes, Your Honor, that's on Jesus Flores. I anticipate that'll take about 15 minutes.
All right, let me know when you're ready.
And Your Honor, in fact, while we wait, I plan on introducing the offense report as State's Exhibit number 1. If Mr. Barrera doesn't have any objections, that I can send that to speed things along.
Mr. Thornton's already tendered the report to me. Judge, we have no objection to the court considering it.
All right, thank you. Please go ahead and send it over.
Okay.
And in the meantime, Your Honor, whenever you have a moment, I was going to ask to go over the docket with you, considering that most of the attorneys or a lot of the attorneys are gone.
All right, give me just a minute. I'm just catching up on all the stuff since me and check.
Yes, Your Honor.
Stephen, was it Jesse Coronado you were saying you were wanting to reset for the plea?
Yes, what I'm going to do is I'm going to move him to January 11th just to get me, so I can have a little bit of time to get his paperwork together. I won't be able to get that signature today, and January 11th is the next setting.
Okay, that's no problem. Just making sure I understood that correctly.
Yes, yes. And let me just confirm that my witness is on Zoom. I believe she is, but let me make sure she turns on her camera, and then we should be ready to go for our hearing.
Just FYI, I think Mr. Briggs is still in the breakout room with the jail.
He is not.
Oh, he's not?
No.
Well, there you
I'm right here, Kenny.
Can I have a breakout room with Mr. Briggs then?
Yes, sir.
Or I guess back to breakout room 2. Thank you.
And Your Honor, my witness is available. She's on Zoom as Melinda.
Okay.
And so we're ready whenever the court is ready, Judge.
Be with you in a moment. Let me finish reading this. All right. And the writ of habeas corpus on Jesus Flores. Are both sides ready?
The defense is ready, Your Honor.
State's ready.
What witnesses are you expecting?
I only have one, Your Honor, and it's Miss Melinda. And I'm sorry, Melinda, what is your last name? Unmute yourself, please.
Martinez.
Melinda Martinez, Judge.
Martinez, do you swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and what charges are pending against the defendant right now, or the, what is relatee? Technically, what's his name in the writ?
In a writ, I am not sure. Sometimes I refer to him as the movant, but we can refer to him as the defendant. That's fine, Judge.
All right, I know there's a relator, so I thought maybe he's a relatee. Okay, what charges are pending against him right now?
My understanding is it is aggravated assault on a public servant with a deadly weapon, which would be a first-degree felony.
That's correct.
Okay, and what is his bond set at?
$300,000.
All right. I've had a chance to look at State's Exhibit number 1, which I believe that there was an agreement that there's no objection to. The offense report or reports in these cases.
Since this is a writ hearing, do we need the defendant present before we begin?
Oh, that's a good idea.
Oh, yes. Yeah, that's a good catch, Brad.
Thank you, Mr. Ford.
Yes.
All right, is he at the jail, I take it?
Yes, we're gonna go over him right now, Judge.
All right, I'm sorry, go ahead.
It's hard to keep track of the 50,000 Brady Bunch people all over the screen.
Yes. And let me ask something that's not evidentiary while we wait for Mr. Flores. What is the law right now on aggravated assault by display of a weapon when it's a simulated weapon?
Well, so it comes down to the law of a deadly weapon. And I mean, it's treated the same as any other context of a deadly weapon. If it's capable in the manner, means, and use of causing serious bodily injury, then it's considered a deadly weapon. There is some case law that I've seen suggesting what a person sees as a simulated weapon in terms of a threat can be considered a deadly weapon, but I haven't really looked into that as much as I would like to comment to the court with authority, but I can't really say for sure on that, but I have seen some suggesting that.
We actually had a trial on this issue in Wilson County a few years back on a guy by the name of Navitas. And with regard to a BB gun, it depends on whether the BB gun was loaded and capable of firing. If the BB gun's loaded and capable of firing, then it can be considered a deadly weapon with the idea that they've fired BB guns at pig's eyes and it's capable of putting out an eye, so it's capable of causing serious bodily injury. If the BB gun is not capable of firing, then there's an issue there because it's not a deadly weapon per se, like a firearm would be. It's not a firearm because it does not use any type of powder or to project the bullet. It's air. So then since it's not a deadly weapon per se, like a firearm, you go to the second analysis, is it capable of causing death or serious bodily injury? If it's unloaded or unusable, then it, our argument during that trial, and we got a directed verdict on it, was that it's not, there's case law saying that it's not,
And in this particular case, in preparing for this hearing, I asked for the office report. The exhibit I plan to introduce is all that I have received. So in terms of the evidence page showing exactly what was recovered, I don't have as much information as I'd like to provide to the court about that. So I can't really speak about whether it was loaded or any of that right now.
Sure.
Okay. And I have Zoom minimized. I can only see who's speaking. Let me know, please, when Mr. Flores gets to the jail. So.
There, Judge.
Thank you. All right, now, recalling In re Jesus Flores, writ of habeas corpus. Are both sides ready?
The defense is ready, Your Honor.
State's ready.
All right, and there's no objection to the admission of State's Exhibit number 1?
Not from the defense, Your Honor.
All right, then without objection, it's admitted. All right, so does the state have anything evidentiary other than its report?
No, just the report, Your Honor.
All right. Go ahead, Mr. Barrera.
The defense would call Melinda Martinez.
Go ahead.
Ms. Martinez, can you please unmute yourself?
Yes. There you go.
Ms. Martinez, you've already previously been sworn in on this matter.
Yes.
How are you familiar with Mr. Flores?
Well, I've been with him for 8 years.
Okay. And you all have been in a relationship for 8 years?
Yes.
You reside with Mr. Flores?
Yes.
Does Mr. Flores have, aside from the case that we're here about, does he have any other charges pending at this time?
No, no charges. He has no charges pending.
Okay, so it's this aggravated assault on a public servant case. That's all he has pending right now?
Yes, sir.
Okay. Where did Mr. Flores grow up?
In Poteet, Texas.
Okay. Did he go to school in Poteet?
Yes, he graduated from here, from Poteet.
Does he still have family in Atascosa County?
Yes, he has a sister and a brother.
Where do they reside?
His brother is in Pleasanton and his sister's in Jordanton.
Okay. Now, you said that you've been residing with Mr. Flores for the last 8 years. Where is that?
Here in Poteet.
Okay. And the home that you all reside in, does Mr. Flores own it or does he rent it?
Rent.
He rents it. Okay. And what is the rent on that? Do you know?
The rent is $525.
And aside from you and Mr. Flores, does anyone else reside in that home?
It's my son, which is his stepson.
Does Mr. Flores work?
Yes, he has his apprentice license for electrical.
And how long has he been doing that type of work?
He's already been doing that for like about 6 years.
And prior to being taken into custody, was he employed?
Yes.
Do you know if he will be allowed to maintain that employment if he is released from jail?
Yes.
If Mr. Flores is released, where would he be residing?
He'll be residing here on my residence, which is our.
Sure. Is Mr.
Which is what? He will be residing in your residence, which is what?
It's here in Poteet.
All right, thank you.
And this is the home that you were referring to earlier?
Yes.
And you said you've been residing with Mr. Flores for 8 years. Has all 8 years been at the same residence?
Yes.
Was he already at that residence prior to you meeting him?
Well, that no.
Okay, so that's a residence that the two of you that he obtained during the course of your relationship?
Yes, but we were still in here in Poteet.
Where were you at previously?
It was the same in Poteet as well.
Just a different house?
Yes, it was just a different house.
Okay, okay. What is Mr. Flores's current income?
Like about, I should say 1,200 every 2 weeks.
Okay, and is that full-time employment?
Yes.
And do you work?
Yes, I currently work here at the Ratama Nursing Home here in Poteet.
How much do you make?
That like about 700 every 2 weeks.
Okay. And then do you all receive any type of government benefit?
Yes, my son gets disability. He gets 783, which is going to be hired up to 798 starting in January.
Okay. And what bills do you all have?
We have
You said the
we
rent
have
was $525?
Yes.
Are there any other bills related to housing? Do you have to pay for land or anything like that?
No, it's just basically the regular bills as in light and water and gas.
Okay. Do you own a vehicle?
Yes.
What make and model and year is the vehicle?
It's a 2011 Chevy Camaro.
And are you making payments on that or do you own it outright?
I'm making payments on that one right now.
Okay. Does Mr. Flores own a vehicle?
Yes.
What is it?
It's I believe a 2005 GMC Canyon.
Okay. And is that the vehicle that he uses for work?
Yes, that's his work truck.
Does he make payments on that or does he own it outright?
No, he owns it.
Do you all have any kind of, well, your son, does he go to school? Is he in daycare?
No, he goes to school.
Okay. Is Mr. Flores, does he have any children that are not your children?
Yes, he has children as well.
How old are they?
Basically that I know one had a birthday yesterday. He has 4 girls.
Okay. Okay. And are they adults or are they still under 17?
They're still in school.
They're still in school.
They're
Okay.
under.
Okay. And so he doesn't have custody of those girls, correct?
No, he doesn't.
Do you know what his monthly child support payment is?
That one I believe it's like about 100 because it's just only for medical support.
Okay. So he pays medical support for the kids?
Yes, it's only medical support.
Okay. And does Mr. Flores have a bank account?
He only has a checking, which is for his employment.
And do you know how much money is in the checking account right now?
Right now, at the moment, currently nothing.
He doesn't have any savings accounts?
That no.
Does he own any stocks or bonds?
No.
Does he own any land?
No.
Does he have any other investments or assets that he could sell in order to raise the money for bail?
That no, he doesn't have no other asset.
the amount that the bail is currently set at, have you talked to any bail bondsmen?
I've talked to some, but the thing is, like, how it is at right now, it's like too high. They don't want to, it just needs to be lowered.
Okay, so how much are they asking for you to come up with in order to get him out?
If it was, to be honest, on that one, if it would be real great, like it would help out if it would at least be at 50,000 or so.
No, that wasn't my question. Listen
Oh, I'm
to my
sorry. I'm
question.
sorry.
My question. It's okay. I know you're nervous. Let me ask you, at the amount that the bail is currently set at, the 300,000, what are the bail bondsmen telling you they need in order to get Mr. Flores out?
Okay, I'm sorry. It's 30,000. I'm sorry.
Okay. And are you all able to come up with the $30,000?
That, no.
We talked about the various bills that you guys have. After paying all of your bills, typically how much do you guys have left at the end of the month?
Usually like about 400. That's about it. But that's not even including that we have to buy for food.
Okay, so you usually have about 400 left, and you need food, gas. After those things are covered, what do you typically have left?
Maybe like about 100.
Okay. Now, is there an amount that you could make in order to get Mr. Flores out on bail while this case is pending?
Right now, at the moment, like I had said, if 50,000 would be awesome. I currently have funds available right now for.
And where are those funds coming from?
It's for myself, from savings.
Okay, so you have a savings account?
Yes.
Okay, how much is in your savings account?
My savings is maybe like about 1,500.
Okay. So then if the bail bond company is asking for 5,000, where is the remaining portion of the 5,000 coming from?
The remaining of 5,000, I guess.
Are they asking you for the 5,000 up front, or is that going to be paid out in payment?
Yes, in payments. They usually ask me like about for 1,000 and the rest in payments. But considering that, I'd rather just give the whole 15 so that bond can drop. You know what I mean?
Okay. And without Mr. Flores's income, are you able to maintain the residence and all of the bills that are owed?
That, no, to be honest, no.
Okay. Because you said that he brings home $1,200 every 2 weeks and you only bring home $700 every 2 weeks.
Yeah. Yes.
If Mr. Flores is released on bail, are there any protective orders or anything like that in place which would keep him from residing with you?
That, no, there's nothing.
Okay. If Mr. Flores is released on bail, are you confident that he would make his court appearances?
Yes. I make sure all the time on that.
Okay. Do you feel that Mr. Flores would pose a danger either to you or to the community if he was out on bail?
That, no.
Okay. Is he currently being treated for any kind of mental health disorders?
That, no.
Is he currently being treated for any type of drug addiction?
That, no.
Okay. I'll pass the witness, Judge.
Mr. Thornton?
Your Honor, I have no questions.
Your Honor, that's all we have.
All right, give me just a moment. Right. Ma'am, are there any firearms in your residence?
That, no.
I'm sorry?
No.
And I'm not asking if you possess any, I'm just asking, are there any in your residence?
That, no.
And on the day in question earlier this month, when Mr. Flores was arrested and you were trying to leave, had he been drinking?
No.
All right, any other questions for this witness?
None from the defense, Your Honor.
No, Your Honor.
All right. Okay, so both sides rest and close?
Yes, the defense rests and close, Your Honor.
State does as well.
And Mr. I take it because you haven't brought forth any criminal record that there's not one, or?
Well, Your Honor, there is a.
In all candor to the court, my client, I believe, has been to TDC for an evading arrest with vehicle. That's my understanding of it.
That's what I'm showing as well.
All right, go ahead.
I believe it was state jail. It was back when it was a state jail.
Okay.
And Your Honor, what we're asking here is, you know, the allegation as alleged is a first-degree felony, which is a serious allegation. I don't know that when the facts of the case are fleshed out, that this may not end up being a third-degree felony. You know, the bail is set at $300,000. We are not asking for a PR bond. We are not asking for bail to be set at, you know, $10,000. We're just asking for reasonable bail. We are asking the court, in light of the fact that Mr. Flores is local. He's born and raised in this community. He's always resided in this community. His family's in this community. He is someone who would show up for court. I think the reports that you have in front of you indicate that the allegation is a BB gun. And so granted, what occurred, if true, is not something that should occur. And certainly it put Mr. Flores and the officers at great risk. But it wasn't a firearm. And again, when all is said and done, this may not even meet the statutory requirements to be a first-degree felony. This is a new case, and all we're asking is that while this case is pending, Mr. Flores be allowed to be released on reasonable bail. He has a job waiting for him. He's got his girlfriend he's been living with for the last 8 years. He's got her stepson. He has his daughters that he works for and he helps support. So we're asking the court to set reasonable bail at $50,000. If there are any other conditions the court needs to put in place to ensure the safety of the community, we have no objection to that, but we are asking that that bail be cut from $300,000 down to $50,000, Your Honor.
All right, Mr. Thornton. I'm sorry, yeah, Mr. Thornton.
No problem. Your Honor, you've had a chance to review the offense report. Certainly whether it's a BB gun or not, people are put in danger when such a situation occurs, not to mention the crossfire between officers and other potential safety issues that could occur. We would leave it up to the discretion of the court what Bell said. We certainly would ask that there be conditions of bond put in place, including no firearms, and the requirement to report for alcohol and drug monitoring, just in case that's an issue with the behavior that was exhibited. Your Honor, outside of that, we'd leave it to the discretion of the court.
All right, anything else from either side?
Nothing from the defense, Your Honor.
All right, I will reduce the bond to $50,000. I'm not going to order an electronic monitoring. I will order drug and alcohol monitoring, and forbid the defendant from possessing firearms. And I'll ask the attorneys to confer on those conditions. If you can reach an agreement, just send me an order that reduces this to writing. If not, we can get that resolved later today or later this week.
I'll confer with Mr. Thornton, Your Honor.
All right.
Thank you.
Okay, then we have a plea bargain or a plea on Ferdine, I believe. Any other announcements before we start that?
Yes, Your Honor, I have an announcement. Mr. Flores, looks like.
Okay, go ahead, Ms. Harkins.
Judge, on page 5, my client Marcelino Esparza.
Right.
We did do a waiver of arraignment, but Judge, I've also filed a motion asking for a court-appointed investigator that I would ask would be reviewed today, just so we can get that going. And we've submitted an order.
All right, yes, just make sure that I have a chance to look at that. Has that been e-filed?
It has, yes, Your Honor.
Okay, all right, go ahead.
Judge.
All right, is that all, Ms. Harkins?
That's all, Judge. Yes, Your Honor.
All right, I think Mr. Flores was next.
Judge, I sent you a waiver on Joe Rodriguez.
No, I had already fixed it by just putting the extension on there, and I sent that back to the coordinator.
That was on Connie, Judge. There was also a Joe Luis Rodriguez that I sent you.
Oh, I'm sorry. All right.
And
we had 2 Rodriguezes.
Right.
Okay, and I will do this one right now.
May I be excused after that, Judge?
Absolutely. All right, and then we have plea on Ferdine.
It'd be Crystal Ferdine, and then there's also a Jose Garza.
Yes, Miss Ferdine is at probation. Mr. Garza is in custody. And as the court will recall, we were up to the actual sentencing in Mr. Garza's plea.
Right. Okay. Let me. Okay. And did we start Ferdine?
We did not. Miss Ferdine, that was the one Mr. Briggs asked to reset today because her ride was leaving that day.
Okay. Yes. All right, let me find Garza from last week. Let's do him first since he's in custody.
He's in custody, and the plea papers were posted to chat on Monday.
I have it right here. If you'll let me know when he's back, or when he's at the jail, ready to go.
We would prefer, if it pleases the court, to do Ms. Ferdine first because she is again having ride issues. So if we could take care of her first so she can go about her business.
All right. Calling State versus Crystal Marie Ferdine. Are both sides ready?
State's ready.
Defense?
Ready.
All right. And are you Ms. Ferdine? Okay, I need you to unmute your computer and please remove your mask.
Yes, sir.
Okay, and how do you pronounce your last name?
Ferdine?
All right, excellent. All right, is Crystal Marie Ferdine your true and correct name?
Yes, sir.
And can you speak, read, and write the English language?
Yes, sir.
And are you a United States citizen?
Yes, sir.
All right, despite your representation that you are a United States citizen, I need to caution you that if that is not true, any plea of guilty by you or finding of guilt by me could result in your deportation or exclusion from this country and or a denial of naturalization benefits. Do you still wish to enter a plea today?
Yes. Oh, no, sorry.
I'm sorry, I didn't understand that.
Do I want to do a plea today?
Do you still, I cautioned you about what the consequences could be if you are not in fact a United States citizen. And now that I've done that, do you still wish to go forward?
Yes, sir.
Okay. All right. Do you have any history of mental health illness?
No, sir.
All right. Counsel, do you believe your client is competent to stand trial?
Yes, Your Honor.
You stand charged by indictment with the state jail felony offense of possession of a controlled substance. Specifically, it's alleged that on or about April 5th, 2019, here in Atascosa County, Texas, you intentionally or knowingly possessed methamphetamine in an amount of less than 1 gram. That alleges a state jail felony, which is punishable by confinement for not less than 180 days and not more than 2 years, and by a fine not to exceed $10,000. So do you understand what you're charged with and what the range of punishment is?
Yes, sir.
Do you understand, ma'am, that the plea bargain agreement you have with the state is not binding on me? I do not have to follow it, but if I should choose not to follow it, I would allow you to withdraw your pleas, your plea.
Yes, sir.
If I do follow the plea bargain that you've worked out with the state and the sentence I impose is not harder on you than what you've agreed to, you understand that you will not be able to appeal this matter?
Yes, sir.
If your plea bargain is for deferred adjudication probation and I was to follow it, I would find that there was enough evidence to say you were guilty, but I would not do so. Instead, I would place you on deferred adjudication probation. And if you successfully complete that, the case against you will be dismissed and you'll have no conviction. You may even be able to get an order of non-disclosure to keep the state from telling anyone other than law enforcement that you were even arrested. The flip side of deferred adjudication is that if, while you're on deferred adjudication, the state alleges that you're breaking the rules, then you could be arrested, you could be brought back to court, and there would be a hearing on just that issue. Are you breaking the rules? And if it turns out that you are breaking the rules, then you could be found guilty at that time, and you could be sentenced to anything that is a legal sentence for a state jail felony. That is anywhere from 180 days to 2 years confinement and a fine not to exceed $10,000. Do you understand that, ma'am?
Yes, sir.
All right, give me just a moment. All right, I want to show you some documents that appear to have your signature. Well, if I can get this to work. Okay. They're titled Admonitions to the Defendant for Plea to the Court. And let me ask on paragraph 2.11, is that your signature? It looks like it's partially obscured. So is that your signature?
Yes.
All right. And on the next page where it says verification, is this your signature?
Yes, sir.
And do you swear or affirm to me that everything above your signature on this page is true and correct?
Yes, sir.
All right. Did you also sign on the certification of appeal?
Yes, sir.
The agreed punishment recommendations?
Yes, sir.
The waiver of preservation of evidence?
Yes, sir.
And the discovery compliance certificate?
Yes, sir.
Did you read these documents yourself, or did your attorney, Mr. Briggs, read them to you before you signed them?
My attorney, Mr. Briggs, read them to me before I signed them.
All right. And did you understand these documents before you signed them?
Yes.
And are you satisfied with the work that Mr. Briggs has done for you?
Yes, sir.
All right. Counsel, do you believe your client understands the nature of the rights she's giving up, the stipulations of evidence she's making, and the consequences of her plea bargain?
Yes, Your Honor.
All right, ma'am. I'll find that you made your waivers of right and your stipulations of evidence knowingly, intelligently, and voluntarily, and I will approve them and accept them. I'll also ask counsel, do you believe that you've received all the discovery you're entitled to in a timely manner?
Yes, Your Honor.
And I will also accept the discovery compliance certificate. And I'll ask you, ma'am, to the offense alleged in the indictment, state jail possession of a controlled substance, do you plead guilty or not guilty?
I'm guilty.
I'm sorry?
Guilty.
Has anyone promised you anything other than your plea bargain with the state to get you to plead guilty?
No. No, sir.
Has anyone harmed or threatened you or anyone close to you for your plea?
No.
Has anyone promised you an early release from your sentence?
No, sir.
All right, I'll find that you made your plea voluntarily and you're not in any compulsion in making it. I'll accept it. And I'll ask what evidence the state has to substantiate the defendant's guilt.
State tender, State's Exhibit 1, it's attachment A.
No objection.
Without objection, State's Exhibit 1 as Attachment A are admitted into evidence. Do both sides rest in?
Say rest and close.
Yes, Your Honor.
Give me a chance to look at their attachments. All right, I'll find there is enough evidence to substantiate the defendant's guilt. Both sides ready for sentencing?
It's ready.
Defense ready? Mr. Briggs, you've got your hand up. It shows, but you're muted.
I'm sorry, Judge. We're ready.
All right. Is there a pre-sentence investigation or a waiver of one?
It's waived.
Okay, what is the plea bargain in this case?
Plea bargain in this case, Your Honor, is for 2 years of deferred adjudication, court costs of $315, restitution of $180 to the Texas Department of Public Safety, no fine, 60 for the supervision fee, $60 drug court program fee, $50 one-time drug testing fee, will be 200 hours community service and all other standard conditions with a drug offender class and drug offender case.
That is our agreement, Judge.
All right, ma'am, you heard what was read in the record by the state's attorney. Is that your agreement with the state?
Yes, sir.
Did the state's attorney add anything or leave anything out?
No, sir.
And how many of your children are residing with you right now?
All 4 of them live with me.
And was Children's Protective Services contacted in this case at all?
No, sir. I did get a case on me, but I don't know if that's what they were They did for, I think it was in the beginning of last year, and I was clean. They did a drug test on me and I was clean. I don't know if that's what the report was on for that, because they didn't know, the CPS people didn't know what the report came from. They couldn't tell me.
Was that after this arrest? And
they didn't even open up.
Richard Perez Sr.
He is out of prison and he has no rights to my children because he didn't cooperate with the system, and he's not in my kid's life at the moment either. My kids can't be around him unattended without me being present in a public place. I have to be in a public place with them if I were to let them be around him.
Anything else from either side?
No, Your Honor.
Nothing from the state, Your Honor.
All right, I will approve the plea bargain in this case and follow it. I'm doing that somewhat reluctantly, ma'am. Putting aside the drug charge, I mean, put that completely aside. Roping your two children into helping you conceal drugs in this case is unconscionable. That could have been charged as a third-degree felony, I think, and you're fortunate that it was not. But I hope for your children's sake that despite that bad example, that they are able to go on and do better in their lives. So I will approve the plea bargain agreement. I found there's enough evidence to say you're guilty, but I will not do so. Instead, I will place you, as I said, on deferred adjudication probation with all the rest of the terms and conditions of your plea bargain agreement with the state. And where do you reside right now, ma'am?
At 813 Avenue F.
In Poteet?
Yes. Kids attend school there as well.
Okay, so you'll be supervised here in Atascosa County on your probation. Keep in mind everything I told you about deferred, that if you do what you're supposed to do, the case will be dismissed, you'll have no conviction. If the state alleges that you are violating the rules, you could be arrested and brought back to court. And if it turns out you are violating the rules, then you could be found guilty and sentenced from 180 days to 2 years confinement and fined up to $10,000. The other thing I'll tell you is that the state has already waived any fine and it's not asking for a fine. I'm not imposing one. And I'm not telling you it's not important to make the payments, but if the only thing you're not doing that you're supposed to be doing is making 100% of your payments on time, you will not be brought back to court and found guilty just for that. We'll give you an opportunity to make larger payments towards the end of the time you're on probation if necessary, and if absolutely required, we can extend you on probation to give you a chance to get everything paid off. So I want to make certain that you don't fail to show up and see your probation officer simply because you don't want to tell them that you don't have the money.
Yes, sir.
Okay. All right, so you understand that because I have followed the plea bargain agreement in this case that you have waived the right to appeal and you may not appeal?
Yes, sir.
All right. I'll find you made your post-trial waivers knowingly, intelligently, and voluntarily, and I will certify to the Court of Appeals that you've waived the right to appeal and you may not appeal. Wish you good luck, ma'am.
Thank you.
Good luck, Ms. Ferdinand.
Thank you.
Judge, may I approach briefly?
Yes.
My client, Jeremy Cantu, who is in custody, he says he wants another attorney. And he wants to approach the judge on that.
All right, well, I don't know that we're going to get to that before we take a break. We're going to finish up the Garza. Are you available at your office, sir?
Yes, I'll be available.
All right. Is he in Atascosa County Jail?
Yes.
No, we're going to finish up with Mr. Garza and then we'll take a break. I'll ask the jail to be available at 2.
Okay. Thank you, Your Honor.
And let's have him in first so we can get that knocked out, and then we can start our contested MTR at 2.
Judge,
Yes, ma'am.
we have a Colton Mann, which was Mr. Baird's person, and he's still on there, and Mr. Baird is no longer on here. And I didn't have a new date for him. That's on page 8.
Yeah, no, I just found him. I don't either. If the coordinator's office could call Mr. Mann, or Mr. Baird rather, I'd appreciate it.
Yes, sir.
Thank you, ma'am. All right. So let me know when Jose Garza gets there.
He's there, Judge.
All right, so recalling State versus Jose Garza. Are both sides ready?
Ready.
Right. My recollection is we left this at the plea bargain stage, and there was some question about how many days credit the defendant was entitled to for a time he spent in jail on this charge. Has that been resolved?
Yes, Your Honor.
Judge, we've reached an agreement on that.
All right, and what is that agreement?
The agreement, Your Honor, is for the original sentence of 10 months in the State Jail Division, Texas Department of Criminal Justice with 280 days credit.
That's correct, Your Honor.
And what was the number on Monday?
270, Your Honor.
All right. Okay. All right. So, Mr. Garza, with that change, is that your plea bargain with the state?
Yes.
All right. And are you asking me to go forward with the plea bargain that was spelled out on Monday?
Yes.
All right. Then I will do so. I previously, I think, found there was enough evidence to show that the defendant had violated the terms of his deferred adjudication probation, and I will at this time find him guilty of a state jail felony of possession of a controlled substance and sentence him to confinement for a period of 10 months in the Department of Criminal Justice. All right, sir, is there any legal reason why sentence should not now be imposed?
No, Your Honor.
All right, it is the order, judgment, decree of the court that you be taken by the sheriff of Atascosa County and transported to the authorized receiving agent of the Department of Criminal Justice. Your sentence will commence today. You'll be confined for 10 months. You'll receive credit for 280 days that have been spent in jail so far on that charge. Your sentence will also run concurrently with any other sentence or sentences you may be under. All right, and you understand, sir, that because I have followed the plea bargain agreement in this case, that you have waived the right to appeal and you may not appeal?
Yes.
I'll find that you made your post-trial waivers knowingly, intelligently, and voluntarily also. And I will certify to the Court of Appeals that you've waived the right to appeal as part of a plea bargain and you may not appeal. I wish you good luck, sir.
Stephen.
All right, hold on. I've got a judgment on somebody here. Verdine. All right, I've just posted the Verdine judgment to the clerk's office. What else do we have right now?
Nothing that I show, Your Honor. I was going to go over the docket with you just to make sure where we're at. If you have a moment.
No, let's do that. All right, Eddie signs 119.
Yes, Your Honor.
Rowinski, I have nothing other than needs new date.
Yes, Your Honor.
Victor Hernandez Nisai.
Yes, Your Honor.
Seiler, all I have is custody.
I show reset for 113.
113. Shapa remain on docket, plus he wants a competency trial, and I said to file that.
When was the reset for, Your Honor?
I think he already has dates, so I said I believe. Is that true? Does he have dates already?
He does not, Your Honor. He just sent a chat that he was going to file the motion in order to have him evaluated. And as soon as we got him an appointment and evaluated, when we get the report back, then we'll set it.
Okay, I thought he said that he'd already been evaluated, but they wanted a jury trial.
No, he just sent on chat that he was going to file a new motion in order.
Okay, I'll look at that when it comes in.
Okay.
Let's see. Araujo and Jacinto, 217. Guerrero, 127. Garces, 217. Guerrero, 127. Araujo and Jacinto, 217. Martinez, Nisai.
Yes, Your Honor.
Matula, 127. Swathart, 111. Dillon, 217. Garces, 217. Hernandez, I don't have anything.
I don't have a date either, Your Honor.
We have 217 for Macario Hernandez. They sent in the waiver.
Jeremy Cantu.
Your Honor, Mr. Quindaz.
Yeah.
Well, he's told. Oh, he's the one that wants to talk. Well, no. Oh, yes, he is. Yes, he is. Sorry. Pardon me.
Bullard, 217. Garcia, 217. Both Garcia's 217. All right, Light.
I show 217, Your Honor.
All right, and had that already been set? I put remain on docket. That's fine.
Yes, waiver of arraignment, I believe.
Okay, Street.
Your Honor, this one is the one that Mr. Quindaz had told me that he's in the Hutchins unit, PDC. We're asking for a reset to 217 so we can get a bench warrant and everything issued for him.
Okay, all right, TDC, bench warrant.
I've already requested with our investigator, so he should be available for that day.
All right, remind me to call in sick that day. It's going to be busy. Navarro, Garcia, Esparza, and Aguilar, 217. Preach, final judgment. Garcia, 113, monitor waiver, and then 217. Garza and Hinkle, 217. James Jordan, no show.
Yes, Your Honor.
Luna, 127. Ahan, 217. Alvarado, Carrasco, Flores, all 217. Roseanne Gomez is an I-sign.
Yes, Your Honor.
Gonzalez, 217. He's in federal custody.
Yes, Your Honor. We're gonna. Mr. Arguelles is going to provide me some paperwork, and I'm going to check with our investigator to see where he's at and if this can be resolved a different way.
All right, Colton Mann, we're trying to get Michael Baird back in here. Moore and Martinez and Moore, 217. Ortiz, Nisai. Connie Rodriguez, 217. Joe Rodriguez, 217. And then Rogers and Santos, the same. Cepeda, no show, nice eye.
Yes, sir.
And I have nothing for Sullivan.
Judge, I'm back on Sullivan.
Yes, Mr. Gear.
Could I get a brief reset date? That was the one that I just got appointed on and his contact information didn't work, but I just, I guess they announced that
We found out he was in custody, yes.
Yeah, he's in custody. Can I get a brief reset to get him a waiver?
That's fine. Just get with Ms. Norma on that.
Okay. Thank you, Judge.
Your Honor, do you want to set it as the 113 monitor and the 217 for the waiver date?
Sounds good.
So 113 monitor, 217 waiver date?
Yes.
I'll type that in. Thank you, Kenny.
Thank you.
Okay, so we're going to be in recess until.
Your Honor, there's Wessels.
Oh, on the next page. Oh, we have the add-ons, yeah.
Yeah, Jessica Wessels and then the remainder.
Wessel is 217.
Reset 217. Okay.
217, yeah. Then on the add-ons, Garza is final judgment. Coronado 111. Talamantes 119. Arwijo
Is the hearing this afternoon?
today. Coronado 117. Ferdine, final judgment. And Gaitan 217, the attorney is the public defender's office.
Yes, Your Honor.
All right. Anything else before we take a lunch break?
No, sir. Thank you, Judge.
All right, I will be back shortly. Well, not shortly. I'll be back by 2. All right, Mr. Mann, does Mr. Baird have good contact information for you?
Yes, sir. Yes, Your Honor.
All right, I will release you right now. He should be getting back to you today with information on when you're supposed to be in court again.
Thank you, Your Honor.
We're on a break right now, Judge.
Yes, give me just, go ahead.
Norma?
Yes, sir.
Hey, how you doing? I've
Good.
got that hearing at 2. I just was making sure. I was going to see if I could talk to the Atascosa County Jail and talk to my client beforehand.
Sure. Let me go ahead and put you in a breakout room with them.
Thank you.
Yes, sir. And who's your client, Mr. Lambert?
Julio Aruejo.
Okay, hold on just a second.
Hijo.
And are we getting Jose Cantu to the sheriff's room? Jeremy Cantu?
Judge Norma had put Mr. Lambert and his client in.
Julio Argijo are in a breakout room, Your
In a break-
Honor.
Oh, okay, okay, never mind.
And I don't actually see Mr. Keen Dawes anymore either. Am I confused here?
No, I don't either.
Okay. Norma, do
Sean's
you know?
iPad, no, Sean's iPad is in the waiting room. Just
Oh, okay, okay.
There he is. All right, Ms. Keen-Dawes, Phil Lambert and his client are conferring, so we can't get you into the jail room right
Okay,
now.
that's fine, Your Honor.
But I'm gonna work on stuff in the judge's queue. So I only have one monitor right now, so please let me know when they come back.
Yes, sir.
Judge, I don't see the jail on here. Do we know if they were?
Yeah, they are in a breakout room right now with Philip.
Oh, okay.
Oh, then Mr. Lambert's back. So the jail should be.
They're coming back. Do we have anybody in the breakout room or in the breakout room, Your Honor? I'm waiting on a witness. He said he was going to log in at 2.
No, in the waiting room, you mean?
Yes, Your Honor.
No. All right, so are we still need a hearing here?
I think so, Your Honor.
Okay. All right. And is the jail back in?
Yes, I just saw the jail.
All right, there it is. Says Atascosa County. Okay. All right. How long are you expecting this to take? A while?
No, probably about an hour.
All right. Let's get Mr. Cantu in so Mr. King-Dawes can take off. So after the jail to bring, is it Jeremy Cantu?
Yes, Your Honor, Jeremy Cantu.
Again, I'm working on my queue if you'll let me know when he gets there.
Yes, sir. Your Honor, he's shown up. I believe that's Mr. Cantu.
All right, calling State versus Jeremy Cantu. I understand, Mr. King-Dawes. Mr. King-Dawes?
Yes, I'm sorry, I'm here.
I understand that Mr. Cantu had indicated he wished to speak to the judge.
Yes, sir.
Yes, sir.
All right. What is going on, Mr. Cantu?
I feel that, strongly believe that me and my lawyer are not on the same page, and I'm not comfortable fighting my case with him. I don't think he has the best interest for me. Yeah. And I believe that I can fight this case, but I'm not. He keeps telling me that he got this and he has this and he's going to come up here and show me this, but he can't show me anything. So if you can please, put it in consideration to getting me a new, reappointing me a new lawyer, I would appreciate that, Your Honor.
Right. So you're saying that you haven't had a chance to meet with him in person?
I have met with him in person. The last time I seen him, he came on a Saturday. But before that, I had talked to him. He says, well, I'm going to show you a video that they have.
Okay, and don't go into the details about,
I apologize. Okay. But he hasn't shown me any of that.
If I may, Your Honor.
Yes, sir.
I have submitted a USB. I submitted it yesterday to have a number of cases have the video put on the USB, and that includes Mr. Cantu's case. And really, and I don't want to go into a whole lot, but there was an issue as far as what the offer is from the state. He obviously he disagreed and he wanted another offer, which I was trying to secure. But anyway, as far as fighting the case, I mean, I'm there with him if he wants to. I should, whenever that USB is ready, I mean, I can visit him with it and show him all the video. Of course, these things take time, and I was busy with all the cases, but I was also under the understanding that he would take a certain offer, which the state is not willing to do yet.
All right, what I'm going to do is I'm going to set this for 1/11. I think that's the first day next month that we're going to be back in court. And hopefully everything has been worked out by then. If not, Mr. Cantu, Mr. Keendalls will have had plenty of time to get with you and show you whatever video he needs to show you, and for you to be able to make some decisions based on that. I mean, if that hasn't happened, then we'll have to revisit this. But I've got a taster. I don't believe that that's the first day the court's going to be available in any event, and I'm not hearing that there's reason to remove Mr. Keendalls right now. And I'm also would suggest to you that there's no other attorney that would get anything else done between now and January the 11th, simply because no one's going to be in court here. So I'll reset it for the 11th, and let's see if you all have an agreement at that time or if we need to revisit this.
Right, thank you, Your Honor.
Okay, and we could get Mr. Arwijo back in.
And Your Honor, if I may.
Yes.
I believe that's the last case I have on the docket, and I think for the most part, the docket's been gone over.
Yes.
I was informed by Mr. Thornton that on Jacob Rowinski, Mr. Adams was going to get in contact with Norma and get a date at a later time so that we can get a bench warrant for him.
Okay.
And the only other one I don't have any notes for is going to be Juan Nieto Chapa on page 1. That was the competency.
Yes, I just have that right now as reset on request.
Okay.
All right. So you are excused then.
Yeah, thank you, Judge. Leave Bradley to leave Bradley.
Yeah.
All right, again, I've only got one monitor. Y'all need to let me know when people get here if we're waiting on folks.
Apologies, sir. Mr. Panagiho is here. Just sit down.
Okay, so let me look at my docket. Calling cause number 20-020031, State versus Julio Arroyo III. on a motion to revoke. Both sides ready?
State's ready.
Defense is ready, Your Honor. We should have a witness logging in soon, but they can wait in the waiting room.
Okay. And let me ask, this is going to be a contest of the allegations in the state's motion to adjudicate, or actually motion to revoke?
That's correct. I believe it was, so we had a motion, a first amended motion to revoke that was filed approximately a month ago. I noticed a small error and I contacted Mr. Lambert and I provided him with a copy of that, I believe, on the 10th, and let him know we were going to be proceeding on that. So that's the second amended motion to revoke.
I have received that, Your Honor. No objections to the second.
I don't have a copy of that.
Let me forward, well.
And officer, is it Venegas?
Venegas, yes, sir.
Okay, Venegas, it's okay. I've muted you a couple of times. If you're not actually testifying, I'm going to ask you to leave your electronic device muted.
Okay.
I'm working on sending that to you now, Judge.
That or posted in chat is good too.
I just sent it to you in chat, Judge.
Thank you. Give me a chance to look this over. All right, Mr. Lambert, I wanted to talk to you and your client, I guess, and Mr. Thornton also, just for a brief period of time. I have reviewed the second amended motion to revoke. I'm not sure exactly how it differs from the first, but there are a number of allegations in that I'll put to both the attorneys. It looks to me like should not be a lot of he said, she said, or any dispute about them. And all I mean by that is, Mr. Araujo either performed his community service hours or he didn't. He either reported to probation or he didn't. I understand there's allegations of new criminal offenses, and that's a whole mini trial in and of itself if the state proceeds on that. But if there's a acknowledgement by the defense that some of the allegations in the MTR are valid, then I would suggest it would be better to enter a plea on that to true and leave all the rest of it to whether every single allegation that the state has made is valid to punishment. or disposition of this case. And I'll say, the state burden is on the state. I'll certainly hold them to their burden. But is that something you've had an opportunity to discuss with your client?
Your Honor, yes, there is. In regards to the ones I believe you're talking about, really, it was technical violations. I was going to go through the state, and you're right, correct. If he didn't do the community service, then he would have to allege true. But I guess I did have an argument for those, all the technicals, and in regards to the
Okay, then that's fine. I just want to make sure we're on the same page.
Yes, I understand that, Your Honor. And yes, we are going to not contest one of them and go to sentencing on that one, Rule 11.
Okay. And so if we're not contesting Rule 11, do we need to have a hearing, or can he just plead true on Rule 11 and then we can set this for a PSI, and then, or skip a PSI and jump directly into punishment?
If we want to do that, Your Honor, we can. I thought this hearing was going to be more in regards to giving testimony on why that is a violation and what happened with that violation and sentencing.
Okay, again, I'm not assuming that there were any violations at all. If you want to contest stuff, absolutely. The state has the burden of proof on that.
Okay.
I have sat through 30 minutes of summary judgment argument sometime with the movement arguing the other side's not entitled to X, Y, and Z. And then the other side stands up and says, well, Judge, we never asked for X, Y, and Z. And I didn't want to have a situation like that this afternoon. So, all right, I'll ask Mr. Thornton to read, one at a time, whatever alleged violations the state is proceeding on. And let me back up first and say, you are Julio Araujo III, are you?
Yes, sir.
And are you the same Julio Araujo III who on or about March 11th, 2020 was found guilty of the third-degree felony offense of assault of a family member with previous convictions?
Yes, sir.
All right. Actually, you were not found guilty. You were given deferred adjudication on that date. And you understand that that means that the judge found there was enough evidence to say that you were guilty, but did not do so. The judge placed you on deferred adjudication probation for a period of 4 years. And if you successfully complete that period of deferred adjudication probation, the charges against you will be dismissed. And you'll have no conviction. But the state has alleged that you violated the rules of your deferred adjudication. And if they can show that that is true, then you could be found guilty and you could be sentenced to anything that is a legal sentence for a third-degree felony. That is 2 to 10 years confinement and a fine up to $10,000.
Yes, sir.
Do you have any history of mental health problems or mental illness?
No, sir.
Okay. All right. And do you speak, read, and write the English language?
Yes, sir.
All right. Go ahead, Mr. Thornton.
So you're just wanting me to read the rule violations that we're proceeding on?
Yes, I'd like you to read them one at a time and then we'll ask Mr. Araujo what whether he's pleading true or not true to that violation.
Rule number 1, that the said defendant Julio Araujo III, during the term of community supervision in the county of Atascosa, state of Texas, on or about the 11th day of September 2020, did then and there intentionally and knowingly enter a habitation of another, namely Yolanda Galvan Araujo, hereafter styled the complainant, without the effective consent of the complainant, and the defendant had noticed that the entry was forbidden.
All right. And Araujo, to that alleged violation, do you plead that it is true or that it is not true?
To be honest, I had no clue of it, to be straightforward with you, but until
Your Honor, that is, I believe, in regards to what you were saying earlier, that would be one that his defense counsel, Robert Greer, and I have spoken. They are challenging that one right now. So in regards to the allegation, how do you plead, Mr. Araujo?
As in?
True or not true? True it did happen or not true it did not happen?
As in, did I know about it?
As in, did
Oh,
that
sir,
violation?
and what it's alleged in rule number 1 is that you committed the misdemeanor offense of criminal trespass on September the 11th of this year by going to the habitation of Yolanda Galvan Arwijo without her effective consent when you had noticed that entry was forbidden. That alleges a Class A misdemeanor offense. So what we need to know, is it true or not true that you committed that Class A misdemeanor offense in Atascosa County on September the 11th of this year?
Would it be like I'm saying? To be honest with you, Your Honor, I didn't know I couldn't be there, and that's where I was living there.
All right, so you're saying that you did not commit that offense?
No.
Sir, the only acceptable pleas to an allegation that you violated a rule of your probation is that it's true you did it, or that it's not true. So asking for an explanation or anything else is true or not true. So what is your plea?
Not true.
All right. Go ahead, Mr. Thornton.
That the said defendant, Julio Arguello III, during the term of this community supervision, failed and refused to obtain and keep honest employment in some lawful and useful occupation.
All right, sir. And do you understand what the state is alleging?
Yes.
Okay, so to that alleged violation, is it true or not true that you failed to obtain and keep honest employment?
Not true.
Okay, again, sir, this is just true or not true is the only acceptable plea.
Okay, yes, sir. No, I
not true. I accept your plea of not true. We'll move on. All right, Mr. Thornton, next, Mr. Thornton.
The said defendant, Julio Arguello III, during the term of his community supervision, failed and refused to report to the supervision officer in person or by letter monthly during the probation period, defaulting on or before the 11th days of June, July, and August of 2020, giving said supervision officer his address, marital status, employment engaged in, and the name and address of his employer, and a recap of monthly expenses.
Sure. So do you understand what the state's alleging with that alleged violation, that you failed to report to your probation officer as you were supposed to in June, July, and August of this year?
Yes, sir.
And is that allegation true or not true?
Yes, sir, it is.
Again, sir, it's not a yes or no question. It must be answered with either true or not true.
True.
I'm sorry?
True.
All right. Go ahead, Mr. Thornton.
Rule number 12, that the said defendant, Julio Arguello III, during the term of this community supervision, failed and refused to report to the supervision officer in person or by letter within 5 days after any charge of violating any law of the state of Texas, any other state or the United States that has been made against you, stating the offense charged in the court in which the charge is filed, said charge being criminal trespass on or about September 11, 2020 in Atascosa County, Texas.
All right. And Mr. Arguello, here, the state has alleged that you were arrested on or about August the 11th here in Atascosa County.
September the 11th, Your Honor.
September the 11th, yes. And that you failed to report that arrest to your probation officer within 5 days. So is that allegation true or not true? Not that you committed a crime on September 11th, but just that one, you were arrested, and two, you did not report that to your probation officer within 5 days. I'm sorry?
Not true, right? I mean,
sir, I wasn't there. Okay, not true. That's great. I just need your plea.
I'm sorry. Not true. I'm sorry.
Go ahead, Mr. Thornton.
Rule 14A, that the said defendant, Julio Arguello III, during the term of this community supervision, failed and refused to pay the supervision fee in the amount of $60 per month during the community supervision period, defaulting the months of April, May, June, July, August, and September, the year 2020.
All right, sir. And to that allegation that you failed to pay your monthly $60 a month supervision fee from April through September, is that true or not true?
Okay, not true because
All right. Go ahead, Mr. Thornton.
Rule 14B, that the said defendant Julio Arguello III, during the term of this community supervision, failed and refused to pay a one-time pre-sentence investigation report fee in the amount of $25, defaulting on or about the 11th day of April, May, June, July, August, and September 2020.
Mr. Araujo, this is alleging that you failed to pay a $25 fee that had been assessed during the months of April through September of this year. Is that true or not true?
that is true, I guess. True.
Okay, sorry, I'm going to ask you to not say that you guess, but again, just whether, is that true or not true?
I mean, that's true.
Okay. All right. And go ahead, Mr. Thornton.
Rule 14D, that the said defendant Julio Arguello III, during the term of this community supervision, failed and refused to pay the court cost in the amount of $315, defaulting on or about the 11th day of April, May, June, July, August, and September of 2020. Said defendant is now in arrears in the total amount.
Okay, and let's skip that part because aren't his other fees, the probation fee and all that, isn't that split up over the term of his?
Yes, that's true.
It is, Your Honor.
All right, so to the allegation that you did not pay court costs amount of $315 or any part of it from April through September of this year, is that true or not true?
True.
I can't hear you.
True.
True. Go ahead, Mr. Thornton.
Rule 17, that the said defendant, Julio Arguello III, during the term of his community supervision, failed and refused to complete 200 hours of community supervision or community service to be served at the rate of at least 16 hours per month if working full-time, or at the rate of 32 hours per month if not employed, defaulting in April, May, June, July, August, and September of 2020.
So this alleges that you failed to do, it looks like as many as 16 or 32 hours a month. I'm not sure if you did any community service hours, but it alleges that at a minimum, you did not do the number of community service restitution hours you were supposed to in April through September of this year. To that, is your plea true or not true?
True.
Go ahead, sir.
Rule 24, that the said defendant, Julio Arguello III, during the term of this community supervision, failed and refused to complete an anger management program as directed by the community supervision officer.
All right, sir. And was there a time limit on this?
I think there usually is. I'm trying to pull up the judgment. Yes, Judge, both of those are required to be completed within 180 days of the date of the order.
All right, sir. So the Rule 24, the state's alleging that you failed, that you were supposed to have, and you failed to complete an anger management program. Is that true or not true?
True, Your Honor.
Go ahead, Mr. Thornton.
Rule 25, that the said defendant, Julio Arguello III, during the term of this community supervision, failed and refused to complete a batter's intervention and prevention program as directed by the community supervision officer.
Right, and again, sir, the allegation is that you were required to complete another program was part of your probation and that you failed to do so. Is that allegation true or not true?
It's true, Your Honor.
All right. So by my count, you pled not true to the alleged violations of rules 1, 6, 12, and 14. And you pled true to the rest. Is that correct? Mr. Lambert?
That is correct, Your Honor.
Okay.
Which some of the, I think he pled not true to 14A, but true to 14B and D.
Oh, okay. Yeah, you have them split down. 14A, not true, 14B and D, you're correct. And I did not, as far as the total that's due, I did not, Mr. Thornton did not ask about that, and I'll just take judicial notice that that's not correct arrearage amount because there's supposed to be payments made over time. Okay, there's a Galaxy A21 in the waiting room.
I believe that is my first witness, Your Honor, Eric.
All right, what is Eric's last name?
Arguijo. He is Mr. Julio's brother.
All right. And is either side going to invoke the rule?
I've just had one witness, and I believe you only have the PO and the officer, correct?
Yes, I'm not going to invoke the rule.
Me neither, Your Honor.
All right, so let me ask all of the witnesses to unmute so I can swear them in. Okay, do each of you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Garza?
I do.
All right, Mr. Arguijo, you're muted. Thank you.
Can you hear me now? I'm sorry, there's a lot of noise because I'm at work right now.
Yes.
I do apologize, Your Honor. This is all I could.
All right. And do you swear or affirm that the testimony you're going to give is true and correct?
Yes.
Okay. All right, and you're at a construction site or something?
Yes, sir.
All right then, sir, I will grant you leave to keep your hat on, even though you're in court.
Take it off.
No, I said I'll give you leave to keep it on since you're at a construction site. All right, and I'm going to ask you to keep your phone muted unless you're actually being spoken to. All right, Mr. Thornton, go ahead.
Your Honor, I'm actually going to start with the probation officer. I'm going to call Veronica Garza.
All right, go ahead.
Get a phone call.
I'm sorry?
I thought I was muted.
Okay. All right, Ms. Garza, can you please spell your name for the court and the record?
Veronica Garza, Veronica.
And how are you employed?
I'm a probation officer in Atascosa County.
And is part of your job to supervise people placed on probation?
Yes, sir.
And were you assigned to supervise Julio Arguijo III?
Yes, sir.
Now, have you been his supervisor since he was placed on probation?
Yes, sir.
And were you the one on the day in which he entered his plea that went over his terms of probation with him?
No, sir.
And do you guys keep records in the ordinary course of business amongst all your probation officers about such activities so that way you can have record of it?
Yes, sir.
And are those called your chronos?
Yes, sir.
And who is the person who went over those conditions of probation with him?
That's Valerie Campos.
Valerie. And what is Valerie's position?
She is a unit manager in Karnes County right now.
Okay. And at the time, she was the unit manager in Atascosa, correct?
Yes, sir.
And did she train you in how to go over the conditions with the probationers?
Yes, sir.
And did she train you to do that the same every time?
Yes, sir.
And is that something that you guys routinely do when going over the conditions with the probationer?
Yes, sir.
And do the chronos indicate that this defendant, that she did go over all the terms of condition with this defendant?
Yes, sir.
And when you do that, do you ask them to indicate their understanding on the terms of condition by initialing the conditions of probation?
Yes, sir.
Okay. And have you reviewed a copy of this order granting deferred adjudication?
Yes, sir.
And does it indicate that this defendant had initialed all of the conditions of probation that are applicable in this case?
Yes, sir.
And are those all the conditions of probation that were read as violations in the motion to revoke earlier?
Yes, sir.
And were there any notes indicating that he did not understand?
No, sir.
Okay. What day was those conditions going over with him?
On March 11th during intake.
And is that the date of the judgment in this case?
Yes, sir.
Okay. Now, when you first met with him, do you also go over the conditions of probation with him?
No, for during the first office visit, we just do a normal office visit, and we also do a TRAS, which is an assessment to see what level of supervision he's going to be placed on.
Got you. Now, when was the first time you met with him?
Let me check on. His office visit was on April 1st of 2020.
On April 1st of 2020?
Yes, sir.
Okay. So the first thing I want to discuss is the first rule violation that the defendant has pled not true to, and that is that the defendant during the term of community supervision failed and refused to obtain and keep honest employment in some lawful and useful occupation. Do you explain to them they have to have a job while they're on probation?
Yes, sir.
Okay. And do you make aware to them that they have to keep you updated with their job every month that they report?
Yes, they have to bring pay stubs.
Okay. And did you discuss that with Mr. Arguello?
I did ask him if he did have a job during our office visit.
Which office visit was that?
The first one on April 1st.
And what did he tell you?
That he was, let me see, that he was not employed.
Okay. And over the course of your visits with him, did you visit with him? Did you have any more office visits after that?
I did go on maternity leave, so my other officers were taking his office visits while I was gone.
Okay. And what other office visits happened after your April office visit?
The next office visit was on May 4th of 20.
And did he report any employment on that date?
No, sir.
After the May date, was there any more visits? Or was that the last time that you had a contact with him?
Yes, he reported again on May 27th.
Was there any job reported on that date?
No, sir.
And how about after that?
That was the last office visit.
Okay. And then so he had pled true to failure to report in June, July, and August. Is that correct?
Yes, sir.
And is that what your records indicate?
No, sir.
They don't indicate that he had failed to report?
No, yes, sir. He didn't report any employment.
Okay. All right. I want to move to allegation number 12, and that's the defendant failed to report to you that he had been arrested for criminal trespass. And so do you go over with them at intake as well that if you get arrested, they got to contact you somehow?
Yes, sir.
And what does it require them to do? What does their condition require them to do?
They have 5 days to report any new arrest by person, phone call, or by letter.
Okay. Now, did you receive a phone call or letter from the defendant that he was supposed to report?
No, sir.
I'm sorry, that he had been arrested.
No, sir.
So the allegation that he was arrested for criminal trespass on September 11th, 2020, you never received any notification from him about that?
No, sir.
And if somebody else in your office receives a letter, are they supposed to enter that into Chronos?
Yes, sir.
And is that something that everyone is trained to do in the ordinary course of business?
Yes, sir.
And is there any indication that anybody in your office had received notice from him about that arrest?
No, sir.
Okay. Now, before I forget, do you see the person on the Zoom call today who reported to you and identified themselves as Mr. Arguello?
Yes, sir.
And can you identify him in some way?
Yes, he is wearing an orange jumpsuit.
No, I like the record to reflect the witnesses identify the defendant.
It shall so reflect.
I'm now on number 14A. The defendant had pled not true to that as well, which is that during the months of April, May, June, July, August, and September, the defendant failed to pay his $60 a month fee. How is that calculated? Is there does he have to pay each one of these fees individually, or is there a large sum that's taken?
They have a monthly payment and that they are giving during intake.
Okay. Did he make any payments while he was on probation?
No, sir.
Okay. Was there any sum on any type of fine, fee, or court cost that was paid by this defendant at any point during his probation?
No, sir.
During the course of his probation, did he complete any community service hours?
No, sir.
That's from the beginning to this date.
Yes, sir. He didn't complete any community service hours.
Okay, I'll pass the witness.
Go ahead, sir.
Thank you, Your Honor. Hi, Ms. Garza. A few questions. Now, we'd spoken prior. You said you did do the initial intake in April 1st, correct?
The intake was completed by Ms. Campos.
Sorry, not the intake, the first meeting.
The first office visit, yes, sir.
Okay, so do you know what date you left for maternity leave? Not precise, and it's not, I don't need a precise, but about that date, I think April 11th is whenever we spoke about it last time.
About, it was in the middle of April. It was before April 19th.
Okay. Now that May 4th visit, do you know who did the reporting whenever he came in?
Yes, sir.
Okay, who was that?
It was Officer Brittany Ibarra.
Brittany, okay. And does it say the questions she asked or what she went over with with Mr. Arguello?
It does show that they spoke about it and he didn't have any changes to his employment.
Okay. Now, in regards to his employment, I do believe I have someone here. So he wasn't working at that time. He didn't get a job until a little bit later. I wonder if you can tell me what was going on in about March.
With COVID?
With COVID, exactly. Was there a issuance by Governor Greg Abbott that the court can take judicial notice of? It is a what is it called? It is a directorate by Governor Abbott, which stated that all businesses should shut down that are not government related or necessary.
Yes.
Would you agree that it is pretty hard to get employment whenever we have a 45% drop off in employment rates?
There were some people that were still working, so.
It was, you're right. Now, I don't know the exact date, but he was able to get employment with his father at Highway 97 Tire Shop and Recycling. Did he ever give anybody information in regards to that job?
No, sir.
Okay. Now, on the May 27th date, whenever he checked in, did he try to bring a payment in?
No.
Okay. I'll put him on the stand in regards to that. In regards to rule number 12, do you happen to know what day he got incarcerated in Atascosa County Jail?
The only notice I have was when he was arrested on September 11th.
Okay. And he was arrested on September 11th and do you know if he was held until today's date in Atascosa Jail?
He's been in the jail since then.
Okay. So he didn't report because he was incarcerated and didn't have the ability to send a letter?
After September, but they are able to send letters from the jail.
Okay. Do you happen to know, was it just anybody who was available that he would contact whenever he would call up to probation while you were out?
I'm not
Or was he
sure.
given a specific probation officer?
I'm not sure how they were doing it while I was out.
Okay. Now, when did you get back from maternity leave?
I got back on June 1st.
June 1st. And I believe that's when y'all scheduled your first setting with him, correct? Your second meeting with him in person?
Yes. It was
Okay.
a person.
What happened during that? Did you contact him or send him a letter giving him a date to show up?
Whenever he reported on May 27th, they did give an appointment to report on the 9th, June 9th.
Okay. And do y'all have any records of him calling and letting y'all know that he'd had a job and he couldn't show up that day?
He did call me and I did reschedule because he did let me know that he wasn't going to be able to make it. And I did reschedule him for the 16th.
Did you tell him anything else during that phone conversation?
Not that I'm aware of. I just gave him his appointment.
Okay. Do you have any records on your chrono of somebody telling him that he had violated and would have an MTR placed on him? Before the June 9th date.
I'm reading the chrono. No.
Okay. Are you aware that Mr. Arguello has any dependents?
Yes.
Do you know how many?
No, sir.
Okay. Do you know how many he personally takes care of?
No, sir.
Okay. I'll pass the witness.
Go ahead, Mr. Thornton.
If you did let him know that there possibly was going to be an MTR issued in June, would you tell him that he can just stop reporting?
No, sir.
Did you ever say to him anything that indicated he didn't have to report or follow up by either a phone call or a visit or a letter in June, July, August, or September of this year?
No, sir.
Now, in terms of the requirement that he notify you, do you go over with them if they're arrested? They have to send a letter or do something to let you know?
Yes, sir, during intake.
Okay, is that something that you guys are specific to address every single time?
Yes, sir.
Okay. And is that something you were trained to do by Val, the person who did intake in this situation?
Yes, sir.
Do you routinely get letters from people who have been arrested letting you know they've been incarcerated to comply with that condition?
Yes, sir.
And are you aware of the policies of the Atascosa County Jail that they do allow the inmates to mail such a letter?
Yes, sir.
Pass the witness.
Mr. Lambert.
No further questions for Your Honor.
That's all I have, Your Honor.
All right, and Mr. Lambert, I'm just trying to clarify. The question was, did someone at adult probation tell your client that they were going to file a motion to have him adjudicated after missing one appointment where he called in to say he couldn't make it?
Your Honor, I am going to put my client on for the limited purposes of answering that question, yes.
All right. All right. Your next witness, Mr. Thornton.
The state calls Officer Venegas with the Pleasanton Police Department.
All right, go ahead.
Officer Venegas, can you please take yourself off mute? Thank you. Can you state your full name for the record?
Sure, Ernest Venegas.
And how are you employed, sir?
I'm a police officer with the city of Pleasanton.
And how long have you worked for Pleasanton?
A little over 4 years.
And are you a licensed peace officer in the state of Texas?
Yes, I am.
And what are your responsibilities? Is it detective, patrol, just very basic?
I'm assigned to traffic right now, but I do we're a smaller agency, so it encompasses everything out there.
Okay. And you understand we're here today on a motion to revoke a case that the defendant had pled guilty to that was actually in an assault family violence back in last year, last year, correct?
Yes, sir.
Do you recall that? And do you recall being the arresting officer on that case from back in, I believe it was November the 18th. Let me give you the exact date. I've lost my PDF here. Let's see. November the 18th of 2019.
Yes.
And were you part of the two officers who made that arrest of this defendant?
Yes, sir.
Okay. And after he was arrested and placed on probation, there's another incident that we're also discussing here today that occurred on September the 11th of 2019. Were you the arresting officer in that case as well?
Yes, I was.
Now, I want to start back on that first date, November the 18th, 2019. Where was the defendant arrested?
He was arrested here in Pleasanton at 221 Adams Street.
Okay, and are you familiar with that address?
Yes, I am.
And have you dealt with this defendant on many occasions?
Yes, I have.
And how about other residents at that address?
I'm sorry?
Does that also include other residents who've been to that address or you have found at that address?
Yes.
Okay. Who is Yolanda Arguello?
That's the defendant's mother.
Okay. And do you know or have you heard whether or not she lives at that address?
I do not believe she does anymore, but at that time, yes.
Okay. Was that her residence as far as you knew?
Yes.
Okay. On that date, well, first tell the court, what is a criminal trespass warning?
That's a warning we issue. It's just a warning. It's a warning only. We give them a paper copy, but we go over with them that if they are to enter wherever it is, whether it be a business or residence, anything marked on that warning, they are no longer allowed back after we issue that. And if they do, they face a criminal offense.
Okay. And do you go over that very specifically with them, that they're not allowed there, period?
Yes.
And what do you tell them if there wants to be some type of change in that? Like what has to happen? Do you have something you explain to them every time?
Yes, I make sure that they go through the police department to get it removed. I always tell them, if anybody invites you back or they say it's okay, that it's always best to go through us, because then we go through this hearsay stuff.
Okay. And how does a criminal trespass warning get issued? Like, why would you issue one?
We only do if the person in charge of that residence or business, if they have the authority to want that person removed and no longer want them back, that's the only time we'll do it.
Okay, so you don't do it because you want to, because you've been requested by someone with authority.
That's correct.
Now, on this day where he was arrested for the assault family violence, you found him at this address. What was the name of that? What was the address again? 221 Adams Street?
Yes.
Now, did you issue him a criminal trespass warning?
Yes, I did.
Okay. Now, previously, I had sent to you a document that I had titled Julio Arguello States Exhibit Number 2. Did you review that?
Yes, sir.
And is that a true and accurate depiction of the criminal trespass warning that you issued this defendant?
Yes.
Okay. Your Honor, this time I'm emailing States Exhibit Number 2. I'm also emailing States Exhibit 1. I'm going to offer that in a minute just for efficiency's sake to both you and opposing counsel. I've already provided that in discovery to opposing counsel, but I'm emailing that to you, and I'm offering States Exhibit 2 in evidence at this time.
Okay, and can you send that in chat? That's usually faster.
I can do that, sure. Give me just a second.
Just post it to everyone, Mr. Thornton.
I can. Okay, it's gone through. Your Honor, yeah, so I'll offer States Exhibit Number 2 at this time.
Right, any objection?
No objections, Your Honor. I have been given this.
All right.
Your Honor, permission to publish and share my screen?
Okay, I'm looking at it on my screen. Go ahead. It's kind of.
I just want to make sure the officer can see it as well.
All right, well, go ahead. Without objection, States Exhibit 2 is admitted into evidence.
Okay, officer, do you see this on the screen here that I'm showing you?
Yes.
Is that what you reviewed previously?
Yes, sir.
And is that the criminal trespass warning that you issued to them?
Yes.
Now, it doesn't say on there specifically. Was I the only person who heard that?
No.
No, I muted Mr. Eric Orwijo. Go ahead.
Okay.
You had asked the last question over. Shay didn't get it.
Okay, I'll start over. Are you able to see that on the screen?
Yes, sir.
And is that the criminal trespass warning you issued?
Yes, sir.
Now, this looks like to be your ticket form that you would use to handwrite a ticket to somebody. Is that right?
That is correct.
And do you have a specific criminal trespass form you use, or is this what all officers in Pleasanton issue?
Yes, our whole agency uses specific.
And is this a way to document that you have provided that criminal trespass warning?
That is correct.
And is that indicated there by where you wrote criminal trespass warning under warnings?
Correct.
Now that signature there on the left-hand side that runs up and down the far left side, whose signature is that?
That's the defendant who we argue.
Okay. And did you witness him sign that document?
Yes.
When you have him sign that document, do you go over with them? They're not allowed at that address?
Yes,
And is that address indicated as 221 West Adams on this sheet?
that is correct.
Okay. So at the end of your explanation, did he indicate that he did not understand or have any questions about what he was supposed to do?
No, sir. With every time I issue, whether it be a warning or a citation, that is actually a part of what I do every single time, is ask if they have questions, concerns on any of it.
Okay. Would you have addressed those and made sure he was completely clear on what was going to happen or what he was required to do with this warning after he was issued it?
Yes, sir.
So now let's fast forward to let me find trying to find my correct document. Okay, so let's fast forward to September 11th, 2020. Were you on patrol that day as well? I'm sorry.
Yes, sir, I was.
Okay. And did you drive by as part of your patrol duties this address of 221 West Ave?
Yes, I did.
Tell us what you saw.
What I observed was Julio Arguijo. He was actually talking to his neighbor. One thing we always look for is change of behavior. When he looked back and saw a patrol car, he immediately turned and began to walk backwards, which, due to my previous training and experience, I believe to be an uncommon thing for somebody. So typically that's somebody engaged in criminal activity, which could be a warrant or anything else.
Okay, and to search for a reason for that, did you run did you recognize him when you saw him as Julio Arguijo?
Yes, I know him from many previous incidents, so I was able to identify him immediately.
Okay, so did you run his name to see if he had any warrants?
Yes, I did.
And what did you discover?
I discovered he had multiple warrants.
Okay, and so did you attempt to make contact with him to discuss those warrants or to place him under arrest?
Not immediately. With his background and how familiar I am with him, I went around the house. I made sure that he didn't leave, so I secluded him to that area, and I had some of my backup units make location before we attempted to take him into custody.
Okay, and did you have backup units respond?
Yes, I did.
And when everyone had arrived and you were prepared, what happened next?
We cleared the yard. We're pretty familiar with Julio and what he does. He's always hiding somewhere, whether it be outside or previously he had it hid in the attic. Once we cleared the yard and we knew he wasn't in the yard, we believed him to be in the house, but because I did not see him enter the house, we knocked on the door and we made contact with a female there. I do not recall her name. I told her I was with the Pleasanton Police Department and I was there for Julio. She said that, and I asked if he was inside. She didn't want to give permission or really say very much if he was or was not inside. But with my previous experiences, I knew Yolanda. I asked her if I could speak with Yolanda, who I believe was out of town, somewhere out of state. I asked her if she would be able to give her a call, which she did, and I spoke with Yolanda Arguijo. I let her know what was going on, and I asked for permission to enter the residence.
Okay, let me stop you right there. Had you spoken to Yolanda before? Were you familiar with her voice?
Many times, yes.
Okay, and were you confident the person you were speaking to was Yolanda?
Yes, sir.
Now, when you spoke to her and asked her for permission, did she grant that permission?
She did. She said he was in the house, and she also granted permission, or she also granted us permission. The way we entered, there's actually, other than the back door, on the front door, there's actually two different doors, and she even let us go through her door to her bedroom, and that's where we started.
Okay. Now, you said previously he had hid in the attic. So were you concerned about that in this situation?
Yes.
Okay, so what did you do?
So when we entered, we heard the footsteps in the attic. I already knew, due to that previous experience where he had hid from us up there, I already knew how to get up there. I went to that back room. It's at the very top of a closet. That's how you enter that attic. I pushed it with my baton. I ordered him to come out, and he agreed to come out.
Okay, and was he taken into custody with no problems at that point?
Yes, no problems after that.
Okay. Now, did you confirm those warrants on him, of course?
Yes, sir.
And do you recall what the warrants were for?
They were for assault family member with previous conviction, which was a 3rd-degree felony, and criminal trespass from actually our department, which is a Class B.
Okay. And so is it possible that assault family violence was just the NTR warrant for this case?
Yes, that's possible.
Okay. That had been issued. All righty. Now, the person who you found in that building or in that home, is that the same person who you issued that criminal trespass warning to?
Yes, sir.
Okay. And so you issued that in November of 2019, and then you found him in the home in September of 2020, right?
That's correct.
Okay. Now, does Pleasanton keep records as a regular course of business if somebody wants to cancel a criminal trespass warning?
So we still have it in our system, and in a little notebook, it'll be voided out. So it'll show that it's no longer active. Yes, sir.
Okay. And did that occur in this case?
No, sir.
Did you verify that it was active when you made that arrest?
I verified myself, and I also had dispatch make sure.
Okay. Now, do you see the person who we spoke about today and referred to as Julio Arguello on this Zoom call?
Yes, I do.
And can you identify him, please?
He has a beard, black hair, light skin, orange jumpsuit.
Okay. Let the record to reflect the witnesses identified the defendant.
It shall.
I pass the witness.
Go ahead, sir.
Thank you, sir. Morning or afternoon, Officer Venegas.
Yes,
a few questions in regards to this case. So I think we can all agree that procedurally, the delivery of the criminal trespass warning is pretty astute. He's signed it, he's given it. Do you let them know how long those last for?
I tell them they last forever.
So in perpetuity?
Yes.
Okay. Now, I read the report. I guess this is the first incident. This is the, in regards to the 11/18/2019, the original search, whenever you showed up to the house and Mr. Arguello was in the attic. How did you verify who was the proper property owner?
I've known, like I said, I've dealt with not only Julio, but a lot of his family in that residence,
Okay.
and it has always been Yolanda Arguello.
As the owner of the property?
Yes, sir. She does allow. I mean, she did allow a lot of different people to stay there. She was the one consistent one since longer than I've been here that has not owned but operated that residence.
Now, I know it's her son, but in regards to landlord-tenant law, if somebody is paying rent, are they legally allowed to stay there?
If somebody's paying rent?
Yes.
Yes, sir.
Okay. In regards to the case with Julio and his mother, did you know if he was paying rent to be there?
I did not. Normally the questions that I ask is if they're staying there, if they're living there at that time.
Okay.
So one thing that we try to do is avoid giving criminal trespass warnings when we know it's a simple dispute that's going to be over in a few minutes and they're going to want to avoid it. So we go over multiple things to make sure that it's going to be, first of all, they really do want it and aren't acting out of spite or anything like that. And we try to make sure to the best that we can that we're issuing it the correct way. Yes, sir.
Now, do I understand it that on both incidences, the 11/18 as well as the 8/26 incidents, was Yolanda present?
She was not present on what 2 dates? I'm sorry.
The original CT, the warning, and then the second violation whenever he was picked. Well, sorry, the two incidents we talked about with Mr. Thornton right now. Whenever you originally gave him the criminal trespass and picked him up in the attic.
The original time that I issued him, she was. The second time I spoke to her over the phone.
Okay. Now, I've just got a question in regards to that. So I've been working for 3 to 4 years in Wilson County. I've seen about 100 videos of your chest cams. I've heard your voice for endless hours, and I don't think I would have been able to recognize your voice with your face if you hadn't had your name underneath it. How often did you speak with Miss Arguijo to understand that that was her voice and that was who you were talking to get consent to enter the house?
She has a very distinct voice.
Okay.
Not to mention the girl who called, she verified it that it was her. And like I said, if I could pull up how many times we've been to that residence in the past 4 years, there's a ton, and most of the time she's there. There's even times that I'd go by and just talk with her because a lot of stuff does happen there. So we had a mutual respect for each other where we would even talk when I would pass by, as opposed to it just being purely off calls or arrests or anything like that.
And do you happen to know, have you been in contact with her since, let's say, September of this year?
The last time I believe I made contact with her was around this time. I know I did after giving her an update, kind of what had happened. But from what I was told, they moved, and I know that residence is being completely redone and has been for a while now.
Yeah, it's my understanding that she has moved on as well, and moved to Amarillo. I haven't verified that yet, nor have I gotten a call back from her. But officer, thank you so much. Those are the only questions I had in regards to the initial CTW and then the secondary pickup. Thank you.
Yes, sir. Thank you.
Mr. Thornton?
I have no more questions from this witness.
I do not expect to have.
How old was the woman that you were speaking with there at the on Adams Street on the September of this year?
The one that called Yolanda?
Yes.
I would say probably in her 30s, maybe late 30s, early 40s.
And did she make any complaint about Mr. Arguijo being there?
You know, she did not at that time. Her main thing is that she wanted Yolanda to be in charge of that residence. So she didn't want to really do much. She kept referring to Yolanda being in charge.
Thank you, sir. Anything else for this witness?
Nothing, Your Honor. Thank you, Officer Venegas.
Nothing from the state, Your Honor.
You're released. Thank you. Is he released completely, or?
Yes, I don't intend to recall him, so we'd ask that he be released.
Me either, Your Honor.
All right, you're released, officer. Thank you. All right,
you.
witnesses from the state.
The state has no other witnesses for this part of the hearing, Your Honor. We would rest.
All right, go ahead, Mr. Lambert.
Well, I'm going to attempt, Your Honor, if we can't hear him. Mr. Arguijo, Eric?
Yes.
Hey, I apologize, man. I know we've been holding on. Thank you so much. Is there any way you have an enclosed area or a vehicle to get into?
Nah, I'm like really far from my vehicle right now.
Well, I've just got a few questions. I'll ask you as quickly as possible, and the state's going to ask you a few, and the judge may as well, okay? So give us a few minutes, and we'll get you out of here. Eric, what is your relation to Julio?
That's my brother.
How are y'all related?
From our mother.
Okay. What is her name?
Yolanda Arguijo.
Okay, and do you happen to know where she currently is?
She moved to Amarillo.
Do you happen to know why?
No.
Okay. In regards to Julio and his situation with your mother, do you know how long he was living there?
My brother lived with my mother like basically all his life.
Okay. You know if he was paying rent while he was there?
Oh, I know that he was giving my mother money while he was working with his dad.
Okay. You bring up working with his dad. Do you happen to know when he got that job? This is his father, not your father, correct?
Yes, we got the same mom, but we got different dads.
And is that Highway 97 Tire Shop and Recycling?
Yeah,
Does that sound familiar?
Yeah, the tire shop there in Jefferson, Texas.
Do you happen to know when Julio started working there?
I know he's been working with his dad since around 18, 19. Then
Okay, hold on.
I apologize. Eric, this is on record, so.
Okay, Mr. Lambert, hold on. All right, Mr. Araujo, I'm going to need to ask you to repeat your last answer because the court reporter is unable to hear. Go ahead.
What was that?
In regards to where Julio was working at Highway 97 Tire Shop and Recycling, does that sound familiar?
Yes, that's there in Jefferson, Texas.
Okay, is that your Julio's father's shop?
Yes, that's his dad's shop.
Do you happen to know when he started working there?
I know that he's been with his dad doing business like that probably since he was like 18, 19.
During 2020, do you happen to know?
Yes, he was working with his dad there.
Okay. Now, you stated that Julio did make payments to Yolanda. Did Yolanda ever state that he did not live there or that she did not want him to stay there?
No.
How close were you with Yolanda?
We're close because there's only me, my two brothers, and my little sister. So she's the only one there for us.
Okay. How often did you see Yolanda?
Oh, every day.
Okay. Your Honor, that's the only questions I have for him. I'll pass the witness.
Thornton.
Now, sir, when you said that he was paying rent, did you see him give money to your mom, to Yolanda?
Yes, sir.
And when was he paying that rent?
Excuse me?
When was he paying that money to her?
Honestly, I don't really know like exactly when, but I know he does give my mom money while he was there.
Now, was he giving her money to help out around the house for bills and whatnot, or was there a formal?
Yeah. Oh, giving her money like to help out with bills and stuff like that.
Okay, so they didn't draft up an agreement for rent. They were just his job was to help out around the house with either food or things like that. Correct?
Yes, sir.
I'll pass the witness.
No further questions, Your Honor. I simply wanted to verify that he did pay money while living at Yolanda's.
Okay, all right. Is Eric Araujo released?
I have no further need for him, Your Honor.
All right, Mr. Eric Araujo, you are released. You can continue listing if you want, or you're free to go. Thank you.
Thank you, Eric. Your Honor, I would like to call Julio on the stand for my last witness for limited purposes of answering the allegations that he claimed true in the statement or in the MTR.
Your Honor, and I would object to that. This is a essentially guilty, true, not true phase of the trial, and where there's not one specific question at issue that allows him to be called for a specific purpose. He's either called as a witness or he's not.
I disagree, Your Honor. He has already been charged with the underlying issue. We only have the issues of true, not true to answer.
Right, and are you wanting to put on evidence on the ones that he answered true or the ones he answered not true?
The ones he, in regards to the allegations of violations that he has committed.
Okay, that doesn't answer my question.
To both true and not true, Your Honor.
All right, and Mr. Thornton, what are you going to want to ask that's beyond the scope of what he is alleged to have done?
Well, Your Honor, I can't think of anything right now. There's no telling what he may bring up or address or whatever. This is a hearing in which there's relevancy to all the issues that have come up. So I mean, he's being called as a witness. I get to go over that. I also get to impeach him with any thing that he may have been convicted of. So all of those things are fair game.
All right, and Mr. Lambert, have you had a chance to, I mean, one of the allegations is of misdemeanor offensive criminal trespass. If he's going to answer about that, then your client will have to waive his Fifth Amendment rights. So have you talked with him about that?
I have, Your Honor. I've also spoken with Robert Greer. I would not like to waive that Fifth Amendment. I believe they are going to be setting that for a jury trial. So I will hold off in regards to that one then.
So you just said that he wanted to testify about all of the allegations. Now he does not want to testify about that one.
We would specifically like to testify in regards to his payment, to give testimony towards whether or not he gave payment while living at Yolanda's property, which would give rise to the landlord-tenant situation that Mr. Greer will be arguing in his jury trial for Rule 1. In regards to Rules 6, 12, 14A, 14B, 14D, 17, 24, and 25 in regards to his interactions with the probation department during the term of his few months at community supervision, and in regards to Rule 2 that he pled true to in regards to the reasoning behind his not showing up during June, July, and August of 2020, which led to the initial MTR on this case.
All right, Mr. Lambert, will either answer questions about the alleged Rule 1 violation or not. I'm not going to let him cherry pick.
Okay.
Some defense. I'll also say there are a number of allegations here. I don't know that it's strictly the law, but the position I always took as a misdemeanor prosecutor was you saw this a lot, this kind of argument, not so much on whether you're a landlord-tenant relationship, but where you've got the girlfriend, boyfriend, and if it was a woman 18 years of age or older, an adult, and she kept calling her boyfriend to come over, what I would tell the parents and the homeowner was that they didn't have a daughter's boyfriend problem, they had a daughter problem, and that I was not going to, file criminal trespass charges when they had a adult who wasn't mentally handicapped or anything, telling the individual that they could come to the house. So I'm not going to make any findings against your client for the purposes of whether it's true or not true that he violated his probation based on the alleged criminal trespass. That's not me saying that I don't find that it's there, but just I'm not going to find that, hold that against him. So what testimony do you want to have from him?
For limited purposes of explaining his actions, Your Honor, then that would be why I'd ask him. But I won't limit it. If Mr. Thornton wants to ask any questions, I'll just advise my client that anything he says could be used against him in any future cases.
Well, Your Honor, if he testifies,
are you going to testify? Is he going to testify about the alleged violation of Rule Number 1 or not?
His knowledge, sorry, Your Honor, the allegations, I challenge what I'll challenge what Mr. Venegas did in the underlying case. He got a phone call that allowed him to, I can get phone calls and go into Fort Knox and take some gold because President Trump told me to go do it.
Your Honor, I'm going to have to object to argument at this point.
Right. Mr. Lambert, I really don't know how else to put this to you. I've just told you that I'm not going to consider
yes, Your Honor,
violation of Rule Number 1. So is he saying he still wants to testify about it? I'm not going to say he can't, but I want to caution him about his self-incrimination rights. And I want to tell you that he's not going to be able to cherry pick this issue or that issue. He's going to have to testify about everything.
Yes, Your Honor, we'll testify. He will testify.
All right. All right, Mr. O'Neill, you understand that under both the federal and the Texas constitutions, you have the right not to answer any questions that might tend to incriminate you. You understand that, sir?
Yes, sir, Your Honor.
And you understand also that you have the right to waive that protection against self-incrimination and to answer questions that might tend to incriminate you. You understand that?
Yes, sir, Your Honor.
Okay. The rule typically is you have to either claim that right or you have to give it up. By that I mean you can't answer a few questions about a matter that might incriminate you and then say, oh, you know, I think I want to stop now. You have to either testify or not testify. So your attorney, Ms. Lambert, has indicated that you wish to testify about the allegations that you committed a criminal trespass at your mother's residence. Have you had a chance to speak with Mr. Lambert about whether you wish to testify or stand on your rights against self-incrimination?
Yes, sir.
Okay. And do you want an opportunity to speak with him in a breakout room right now where it's just the two of you?
Yes, sir.
I would, Your Honor.
All right. Is Norma online?
Yes, sir, I am. I'll go in breakout
All
room
right,
number
thank you.
4.
All right. And I'm going to step away to get something to drink. I'll be right back.
Appreciate it.
You said breakout room 4, Norma?
It is, yes, sir, breakout room number 4.
My husband goes, cool, then we can have them all for. But anyways, you take this chocolate home and you get 4 steaming hot cookies, and then you just slowly and it is the cutest thing. Look it up on Chocolate Moms, and he'll give you a demonstration of it on the video at that Hannah, whatever, Fernandez Cafe. And look it up and he'll show you how to do it. Thank you.
All right, give me just a moment. All right, we're back on the record. Mr. Lambert, after having had a chance to speak with your client, is he still wanting to testify in rule number 1, alleged violation?
I have, Your Honor, and he does.
Okay. All right. Go ahead, Mr. Lambert.
Julio, I don't believe he was sworn in, Your Honor.
Oh, I thought I had, no? Oh,
You
I
did the witness.
sworn his brother, yes. All right, would you raise, all right, Mr. Araujo, do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
All right, go ahead, Mr. Lambert.
Thank you, Your Honor. Julio, so in regards to your mother, Yolanda, how long had you been at that location?
I've been over there over, I've always lived with my mom over.
Did you move out at a certain point and then move back in?
I mean, I would go stay at my baby's mother's or stuff like that, but I never really, how would I say it? I never really left my mom's, you know what I'm saying? Like I've always been there. I've always helped.
Did y'all ever have, did you and your mother ever have a formal contract on your living situation?
No, I just had to help her with the rent, like water bill, stuff like that.
So was it customary? It was just something that had happened over a long course of time?
Yeah, it was just me being there, like to help her out, to ease it up on her. So that was, as in paying rent, like I would give her money for the rent. I would give her money for the light bill.
And Julio, the stenographer up there is recording, so speak precisely and slowly. Who picked you up from jail?
My mother, Yolanda Argujo.
Where did she take you?
To the probation office, and from the probation office home to her house.
Now, in regards to the probation, do you recall checking in with Miss Garza?
I did check in with, I'm not, if I'm mistaken, it was her. I'm not too sure. I think it was. And
you think it was her or not her?
I think it was her.
Okay. Do you recall talking to her, Miss Garza, ever again throughout your probation?
The last time, whenever she had wanted me to go report at 7 in the morning, when I told her I had no ride, and I was working, like, and I did inform them that I was working with my dad, you know, and I did send in a payment of $180, which got sent back to me. And if she's still on, I don't know if it was the lady at the front desk or one of the, I guess.
Objection, Your Honor, narrative and compound answer. He's talked about 2 or 3 different things. I'm not even sure which question he's responding to at this point.
Sustained.
And Mr. Arguello, let me ask the question and answer that question specifically, okay?
Yes, sir.
Okay. Do you recall who you spoke with on March 11th? That was the date you did your plea.
That was the day that I was already incarcerated, right?
I believe, I don't know if you were incarcerated or not, but you did your initial signing of the contract for probation that day.
I think it was, I don't remember her name.
Did you only meet her that one time?
Yes.
Okay. And then on April 1st was your first check-in date. You met somebody else, correct?
Yes.
And then on May 4th, the next time you checked in, you met somebody else, correct?
Yes, sir.
And then on May 27th, when you checked in again, you met with somebody else, correct?
Yes, sir.
At any point, did you meet the same person twice?
No.
Do you happen to remember anybody's name that you checked in with?
To be honest with you, I don't want to say something and be wrong about it. I really don't.
Okay. Did they inform you that you did have a probation officer?
They said I had a probation officer, but that she wasn't there. She was on maternity relief, or
Okay.
she was pregnant.
So who did you primarily communicate with in probation?
I guess there were other probation officers inside the probation office.
Okay.
They were never the same one.
Did you ever, on that first initial meeting with Mrs. Garza on April 1st, did she give you locations that were open at that time to do a anger management program?
No, sir.
Did she give you a location that you could go to do a BIPP course? That is the Batterers Intervention and Prevention Program.
No. No.
Is there a reason why?
I would think due to the COVID, or you know what I mean, because of the fact that you couldn't go anywhere at that time at all. Like you can barely go into a into a store, a convenience store.
Okay. Now you stated you made a payment. You happen to remember when you made that payment or tried to make that payment?
I'm not too sure, but I know it was $180. And I talked to somebody there. I don't know if it was the lady at the front desk, because she said no, that it would get sent back.
Okay. Why did she? So you spoke to somebody in probation and they said it got sent back, or that it would get sent back?
That it was going to get sent back because I sent it to the wrong place.
Where did you send it?
I think I sent it straight there, and it had to be sent to it had to be sent somewhere for the probation, but I think I sent it to the probation officer or something like that.
Okay, so you did try to make a payment. Did you try to make any, was this while you were working or before you started working?
That was right around the time when I was barely going to start working.
And where did you get a job?
With my dad at the Highway 97 Tire Shop and Recycling. It was on and off. Excuse me?
Is that a salary job or an hourly job?
Well, my dad would just pay me weekly. Like I didn't have a check stub. I also informed him of that. Like my dad was paying me cash.
Were you just kind of helping out your dad, or did he need the help during COVID?
I was just helping my dad. Like I've always helped my dad. Do you know what I mean? Like that was my way of income all the time, for sure. I was helping and working with my dad to own his own business.
Now on June, you got notified that you had to turn yourself into probation, correct? Or go check in with probation.
Yes.
Now you couldn't come that day and you contacted Miss Garza, correct?
Yes, sir.
He was back and y'all made a new date.
Yes, sir.
Now, was it Miss Garza or was it somebody else who informed you that there was going to be an MTR, a motion to revoke placed on you?
I think it was another probation officer that told me that if I didn't show up at that 7 o'clock in the morning, which I told him I didn't have a ride, like I couldn't get there at 7 o'clock in the morning. She said that an MTR would be put out for me.
Okay. Now I've asked Ms. Garza and she said that she did not, nor is there a record of that. Do you have a name or a person that you spoke to?
Oh man, I'm not too sure if it's, I don't know if it was the lady at the front desk. Like I said, I don't want to say something and it not be right. You know, I'm sorry.
Now, do you have any dependents? Anybody, any children?
Yes.
How many?
3. That I take care of.
Excuse me?
I take care of 3 of my sons.
Okay. Now, who do you personally, I know you paid child support for 2, correct?
Yes.
And then you have joint conservatorship on the 3rd one, correct?
Yes. Yes, sir.
Do you see him weekly?
Yes, when I'm out there, I have, yes.
So whenever you failed to show up in June, was it because you were scared you were going to get put in prison?
Yes, sir.
Okay. If you were put on probation, what would you do differently in the future?
I would make sure that I show up and not do that again, to go through all this, because I've caused my kids a lot of suffering, and they really do need me out there.
Was it confusing because you talked to a different person in probation every time you went in?
Yes, sir.
In regards to your $25 payment for the PSI, were you informed that you had to make payments monthly to the probation?
I knew I had to make payments, but I didn't know that they had to all be done like that, since I had a 4-year span. So I also got told by one of the probation officers when I first went that I had up to them 4 years to pay all that off, the court fees, the probation. So that's another reason. And then that's whenever I sent 180 at one time.
When you had the money?
Yes.
What about the community supervision? Why hadn't you started that?
Because there was no places to really go do that at because of the COVID.
Your Honor, that's all I have for the defendant right now. I'll pass the witness.
Go ahead, Mr. Thornton.
And I think he stepped away. I heard him get called.
No, I'm here. No. Sir, I've got a few questions for you. Let me show you a copy of your deferred adjudication order that you signed in this case. Judge, may I share the screen?
Yes.
Do you recall signing this? Is this your signature right here?
Yes.
Okay. And this is, of course, your conditions of probation. And you see the judge who signed this right here?
Yes, sir.
And do you recognize the judge who's here today as the same judge who placed you on probation?
Yes, sir.
Okay. Now, when this judge placed you on probation, he's usually very specific to go over conditions of probation and what is likely and what not likely to get revoked, specifically paying money. Do you recall him talking to you about how important it is to report to probation, even if you're not able to pay money?
Yes, sir. And I was reporting.
Well, I'm just asking you, do you recall that conversation?
Yes, sir. Yes, sir.
Okay. And do you recall him telling you that you got to show up, you have to continue making contact, and that just not paying money won't get you revoked? And that's all it is. But you have to keep in contact, and you have to do the other things that probation has asked you to do.
Yes, sir.
Okay. And did you understand that it was very important to be familiar with your rules of probation, follow them just as they're written in this document, so that way you wouldn't get revoked? Did you understand that when he told you that?
Yes, sir.
Okay. And were you given a copy of this document?
I'm pretty sure I was.
Okay. Now, how about these right here? Are these your initials next to these conditions?
Yes, sir.
Okay. So you initialed this stating that that you will attend, participate in, and successfully complete a family violence program, which here is referred to as BIP, within 180 days. The Batterers Intervention Prevention Program.
Yes, sir.
So you knew that was a condition?
Yes, sir.
And you thought because of COVID you didn't have to do it. Did you follow up with probation and ask to be scheduled for that?
You see, that I thought that had to be left up to me, and I have that from that governor, that Greg Abbott. Like, I have all that to where it shows about me. Like, it's not that I didn't want to go; it's that it was finding the place to go. I didn't have.
Okay, well, did you attempt to find a place to go?
Yes, but
how did you attempt to find a place to go?
I had tried looking up on the internet, really, and
well, let me ask you this.
I didn't have.
All right, sir. Just to say, I'm asking a question.
Yes,
did
sir.
you contact probation and ask them where you should report to complete that?
To be honest, no, because I didn't have a direct probation officer to even ask. And every
Okay,
time,
did you call the main phone number and ask to speak to somebody?
well, yes, and like they would tell me, I just never had a probation officer that could directly tell me where to go, because like I had a different probation officer every time, because my
Okay, did you ask any probation officer, how can I complete this? Please sign me up.
Yes, and they told me that they would let me know that they were going to try and find somewhere for me to go. I just never got up to date with any of that. They never told me after me asking.
When you followed up, did you ever try to follow up to find out?
Yes, every time I would call and they would tell me that either they would let me know or for me to keep calling and asking them. And every time that they did that, it was always another person that I was talking to. So it was just like a new page with them, like telling
Okay.
them.
How about community service? Did you ask if you could complete community service?
Yes, and I knew I could go to like the Cowboy Fellowship and stuff like that. And every time that I would go, I couldn't go because of the COVID. They weren't allowing nobody to do hours.
Okay. Did you call and tell probation that?
Yes, they knew. They knew that. That's one thing they knew too, that it was hard for me. They even told me too that it's going to be hard for me to get a stable place for me to be able to do them community service hours.
Okay. Now, here on your order, do you see where it says payments are to be made to the district clerk at the courthouse and to be made in the form of a cashier's check or a money order? You see that right here?
Yes, sir, I do.
Okay. So how did you submit that payment?
To be honest with you, I think to know, like for reals, I sent it to the adult probation office here in Jordanton, and they informed me that it would be getting sent back to me because it wasn't the right place to send it.
Did it get sent back to you?
Yes.
Did you try to send it to the correct place?
To be honest, it was already around the time that that I couldn't do nothing about it no more. Like,
you say you can't do nothing about it. What time is that? Why couldn't you do something about it?
Well, I mean, I could have, but I had like the address on there on the money order. I don't know how. I didn't know how to. It already said to the adult probation office, you know what I mean? And for me to try to get them to overwrite that and to put to the Atascosa County Clerk's office, that really didn't. It was been hard to do. So I still got
to try.
Yes, sir, and I still have the money order there. Wherever my stuff's at now.
Did you take it to the bank and see if you could switch it over?
No, sir. I didn't even know you can. I didn't know you can do that at the bank. Like I just went to the store where I got it at.
And you went to the store. What did they tell you?
That I couldn't just get it changed over. That it couldn't be just. I could because it said on there to the adult probation office. So it was already typed out on there. So it had to be a new.
What store did you go to?
To the HEB.
Now, all right, just a second. Let me turn this off. So when you were arrested, did you attempt to send a letter to call probation to let them know you had been arrested?
Well, you see, whenever I got that, like I was already incarcerated and it had me in the front for a couple of days. So before I could even do anything, before getting brought to the back to where you can get envelopes, paper, a pencil, you're housed in the front for a couple of days. And by the time that happened, my probation officer had already come to see me and I was still in the front. So I didn't have a chance to come to write her or anything. But afterwards, I did write her and tell her, that I wanted to know what's going on about my court date and everything.
Okay, so how many days after you were incarcerated did she come see you?
It was a couple of days after I was incarcerated.
Was it more than 5 days?
Maybe. I don't want to say yes and then I'm not too sure. It's been a couple of months since then.
Okay. Now, you have been convicted of a felony offense, correct?
Yes, sir.
And on July 16, 2017, you were convicted of the state jail offense of possession of a controlled substance less than a gram, correct?
Yes.
And you were placed on probation for that, and you were revoked from that probation, and you were sentenced to 9 months in state jail, correct?
Yes.
And then on July 21st, 2017, you were convicted of credit card or debit card abuse, a state jail felony, correct? Is that correct?
I didn't hear that response.
I'm not even, yes.
Okay. And you were sentenced to 6 months in the state jail, correct?
Yes, sir.
And that was out of McMullen County, correct? You remember that?
Yes. But since then, I really never got into any kind of trouble. I mean, I've had my kids now, you know, I had gotten my joint custody of my kids and doing all that. So I really wasn't out there doing anything wrong besides working and trying to provide for my kids.
Okay, so you say you haven't gotten in trouble since then. So let's talk about something else. Let's talk about February 28, 2019. You were arrested and charged with criminal mischief, correct? And you pled guilty to criminal mischief?
Not that I recall.
You recall on February 28th in the Atascosa County Court being sentenced to 14 days county jail for criminal mischief?
I don't even remember going to court on that. Maybe I was here, but if that's what it says, well then, I mean, that's what it is.
And that arose out of the same incident, or that arose out of another incident where you were charged with assault of a family member with a previous conviction. You remember that? And there also being a criminal mischief charge attached to it?
Yeah.
So that's a yes?
Yes, sir.
Okay. And so you said you hadn't been in trouble anymore since then. In fact, you were arrested at least 4 different times after that date, correct?
No, because if some of them probably were at the same time that I got, they weren't all different separate times.
Okay, well, let's go over them. So you were convicted of that credit card abuse on July 21st, 2017. And then the arrest for that case came on September 6, 2016. Does that sound about right in McMullen County?
Yes, sir.
Okay. And then so after that date, after you pled on July 21st, 2017, you were arrested on October 31st, 2017 for PCS 1 to 4 grams at my Pleasanton Police Department. Remember that?
Yes, sir. And that time, that because somebody didn't take the blame for something that was, so we all got charged with it. It wasn't just one person.
But you were arrested, right?
Yes.
Yeah, and you were also arrested for assault, a Class C misdemeanor that day too, right?
Yes.
Okay. And on August 10th, 2018 is when you were arrested for that criminal mischief that you pled to, and you got 14 days county jail. Remember that?
Yes.
Along with the assault, family violence with previous conviction, correct?
Yes.
Okay. And then after that, on May 17th, 2019, you were arrested for assault, family violence, family member again. And that case was eventually dismissed in March. Remember that?
Yes.
Okay. And then on November 18th, 2019, you were arrested for assault, family violence, family member with previous conviction. And on that one is what you pled to get deferred adjudication that got us here today, correct?
Yes, sir. I have an affidavit that was written that then too. I got a written affidavit notarizing everything from the person that it stating everything. I have it right here, right in front of me.
Okay, but you did plead guilty to it, didn't you?
That's because my lawyer.
Well, Your Honor, I mean, Your Honor, I object. Non-responsive.
Mr. Araujo, I need to direct you to answer the questions. Sometimes the answer is yes, but an explanation, just answer the question when Mr. Thornton is speaking to you. If Mr. Lambert wants to come back and ask you what the but was, he'll have an opportunity to do that.
Okay, yes, sir. I'm sorry, Your Honor.
All right, so yes or no, you pled guilty, correct?
Yes.
Okay, and you were placed on deferred, and then after that, you were arrested for, well, you had a warrant issued for your arrest for criminal trespass based off of a incident that happened on August 26, 2020 at your mom's house on Adams Street. You remember that?
To be honest, I don't. I'm not going to sit here and tell you that I do.
Do you recall?
On what date, Mr.?
August 26, 2020. Do you recall your mom calling the police because of a disturbance where you accused her of taking your max, which of course referring to synthetic marijuana?
All right, and let me state that would be could have been charged, Mr. Thornton, as a rule number 1 violation?
It could have been charged. It is the offense that he was charged with before this criminal trespass that we've now alleged that shows that that criminal trespass warning was still in effect because he had that warrant outstanding when he committed the second one. So it's not like he didn't know there was still this, he wasn't allowed to go there because he had a new pending criminal trespass charge.
And just so, Your Honor, one thing.
I'm asking questions.
All right, Mr. Lambert, okay. Are you trying to say something?
No, I'm informing him. We'll get to that, Mr. Araujo. You answer the questions of Mr. Thornton and we'll get to that afterwards.
All right,
okay?
I'm going to ask you to unmute your speakers now or your microphone. Go ahead, Mr. Thornton.
So do you recall getting into that dispute about her selling your max?
Her selling? No.
Or her taking your max?
No, sir.
Okay. So,
An objection to that, Your Honor, that is an unadjudicated offense. I believe that's just a police report and a pending criminal trespass charge right now.
All right, so what's your objection?
Objection to relevance of what happened. I don't think that that's
Your Honor, the relevance is that this was another criminal trespass that happened a month before the one we're here today, and it goes to the relevance that he knew he wasn't allowed at that residence.
It's still a pending charge, Your Honor, that I believe is going to the court.
He decided he wanted to waive all that.
I'll overrule the objection.
Do you recall her calling the police and you running out of the house?
No, because to be honest, I don't even recall that because if I really couldn't be there, I wouldn't have been there. But like I say, in all reality, that's where I lived at. Like I paid bills there, you know. I didn't.
Well, sure, but when she called the police on you, didn't you run from them?
No.
No, you don't recall that?
No. If that was so and I was there, I would have, or they would have gotten, I would have been arrested that day if I had a warrant. That's what I say about like.
Well, did you know that they in fact looked for you that day and could not find you, and that's why the warrant was issued?
No, sir. I didn't know until the day that I got arrested this last time about all this. And Officer Venegas knows it too because I had asked him, I was like, I didn't even know nothing about that. Like,
okay, so when Officer Venegas says he drove by and saw you and you backed up acting like you wanted to get away from him, why was that? Why did you act that way?
I didn't even I was at my neighbor's house. I mean, so of course, you know, like I was talking to my neighbor. My neighbor lives to the right of me and he was already taking off to work. So I was coming back to my house.
Okay, so why did you go into your house and hide in the attic?
That was
That was
like,
case.
Sorry?
Sorry?
That was on the 8th. I believe you're getting the two incidents mixed
No,
up.
we've already started talking about the September 11th.
11/18/2019.
So on the September 11th date, why did you go and hide in the attic?
well, that was afterwards. Whenever like I didn't, to be honest with you, like I didn't know what was going on. Like I really didn't know what was going on. I mean, if I would have known that I was gonna go to jail, I'm not gonna run from it. Just how he told you, I came down willingly, not forced. They didn't have to force me. I came down willingly.
Sure, but why did you go there in the first place?
Excuse me?
Why would you go in the attic in the first place?
I mean, it's our house. Like we got stuff up there that we keep up in the attic. You know what I mean? Like I didn't just go up there just to go up there for no reason. Like there's stuff.
What were you looking for in the attic, sir? What were you looking for in the attic?
To be honest, I was getting stuff down that I was honestly gonna take to my cousin's house.
Okay, and you closed the attic behind you?
No, the attic closes by itself. It's a pull down attic.
Okay, I want to go back to when you talked about the calling the probation officer and telling them you had to go to work. You remember that?
Yes.
So you said you couldn't be there at 7 o'clock. Is that right? Yes or no?
Yes, sir. I didn't have a right to.
Yes or no?
Yes, sir.
Okay. And so when you called, they offered to reschedule you, correct?
Yes. No. After that time, I didn't talk to a probation officer. After that, when I said I couldn't report that I couldn't be there at 7 o'clock in the morning, I never talked to anybody after that.
Well, but you had them on the phone. You didn't say, I'm not going to be there at 7, and they hung up on you, right? You continued your conversation.
I told them, and she said that they were going to issue out an MTR or something like that for me. That's what was told to me. And then, yeah, they didn't.
So when she testified earlier that she actually helped you and rescheduled another date to come back, that was incorrect. She wasn't telling the truth. Is that right?
After this, at 7 o'clock in the morning, I don't know if they even told me about rescheduling it, because they told me that it was going to be an MTR if I didn't go that morning. That's exactly what was said to me.
Well, now, had they already rescheduled you to 7? Was that your second reschedule, or was that your original appointment?
That was my second appointment.
Okay, so that you had called before that and rescheduled to the 7 o'clock.
Yes, but I called. I didn't reschedule to the 7 o'clock. She had told me that it was going to be at 7 o'clock, and that's whenever I told her I'm going to try to get there, because it was a couple of days after. And she said that was fine. And the day that I was supposed to go report at 7 o'clock in the morning, I called her, letting her know. She didn't have to call me. I did not just not show up. I called her and informed her of it.
Well, did you try to immediately go to the probation office and try to meet with them at any time after that?
To be honest with you, no, sir, because I was scared. I had the whole thing with the COVID, and then me with my kids, having to provide for my kids. Like, it was just, I had to provide for my kids. And
you understood, and that takes us back to, you made that decision not to go and report to probation, knowing that this judge, the one who's here today pronouncing sentence to you, told you that the one thing that you got to do is keep in contact with probation. You've got to report, and you've got to follow up with them. And that's the most important thing. Remember, and he told you that, right? You remember that?
Yes, sir. And I was doing that. No, and I was doing that.
He told you that.
Yes.
No? And you made that decision knowing that, correct?
Yes, sir.
All right, thank you. I'll pass the witness.
But I was going.
All right. And let me ask, what's the name of the tire shop that Mr. Araujo works at, RTS?
It is Highway 97 Tire Shop and Recycling.
All right. Thank you. Go ahead, Mr. Lambert.
Thank you, Your Honor. Julio, in regards to the November 18th, 2019, were you arrested for criminal trespass that day?
When was that again, sir?
November 19th, 2019. November 18th, 2019.
I don't know if I was arrested or I don't think
You
I
were
was.
arrested on a warrant, but you were not arrested for a criminal trespass.
No.
You were given a warning, correct?
Yes.
Did you ever contact your mother or speak with her after that date?
Yeah. Like I stayed there. That's what I don't get. Like
After getting out of jail from that event, did
Yes.
she pick you up from incarceration?
From here, right in front of the jail, and took me to go report to the adult probation office. And with
On August 26th, 2020, were you arrested for anything other than a criminal trespass?
I think it was that warrant, like, and I didn't know I had that criminal trespassing I didn't know until that day that Officer Venegas told me, and I was telling them, you know, like.
This was after the fact. On that date, you were arrested for a criminal trespass, correct?
Yes.
Not for any drug-related charges or anything else?
No, sir.
Okay. In regards to your underlying case to this, the female individual involved in that case has written you an affidavit, correct?
Yes, sir.
Now,
Oh, what underlying case?
The assault charge in this case, Your Honor, that led to the deferred adjudication.
Okay, go ahead.
We have spoken about that, and you understand that you've already pled guilty to this case, correct?
Yes, sir.
And that was due to the fact that you did not want to go to a jury trial and that a deferred adjudication would get you out of jail quicker, correct?
Yes, sir.
Now, you understand that the guilty plea does not change anything. It's still a guilty plea.
Yes, sir.
You're not trying to hide from your punishment, correct?
No, sir.
You understand that wrong was done and that you want to do right, correct?
Yes, sir.
If you understand that if a deferred adjudication has been taken off the table because of your violation in this case.
Yes, sir.
And that if given the chance, you would continue on probation with full-hearted agreement with the probation office?
Yes, sir. Yeah.
You would pay fines?
Yes, sir.
Work a job?
Yes, sir. And now they got all the information of like my job and everything. So
now, if released, you no longer would be living with your mother, correct?
No, sir.
Now, Eric, who was on the phone earlier, has he stated he would allow you to live with him?
Yes, sir.
Where does he live?
He lives in Floresville.
Okay, do you have an address there?
It's 2220 10th Street, Raymondville, Floresville, Texas.
Okay. In regards to your mother, have you spoken to her since you've been incarcerated?
No, I hadn't, like, she moved up and left. Like, nobody's really talked to her since.
Now, that property, Officer Venegas has said that somebody has purchased that property and is changing it. Who was the owner of that property?
I'm not even sure.
Was your mother renting?
Yes.
Okay.
She was doing a rent to own or whatever. That's why I really don't even get why she even moved. Like, she was really.
No further questions, Your Honor.
I have no questions, Your Honor.
All right, so both sides rest and close.
State does, Your Honor.
Defense does too, Your Honor.
All right, argument.
I'll let state go first.
I'll reserve, Your Honor, for rebuttal.
I'll go then, Your Honor. Julio has had a criminal history. He knows the ins and outs of the law. He got a second chance on this deferred adjudication, and he got scared as soon as he violated. He wasn't able to make the payments. He did not have a job for a long time, and his housing situation sounds like not fantastic. He has since, during COVID, gotten closer with his family. He is now doing joint conservatorship with one of his sons. He is paying child support. He is able to be in compliance. The situation that led to him being here is a majority of his fault of not checking in, not doing right, but he also was very confused. He had to check in with a probation officer who was out on maternity leave. He attempted to contact probation and potentially it just so happened to fall in the lap of somebody who was busy or couldn't handle it. And he was not able to get a lot of his community supervision, his BIP courses, or his other stuff done in time to satisfy the court. He has a job with his father that he'll be able to get back to if he's released. We understand that deferred adjudication should be taken off the table, but if possible, we would ask for probation and a time period satisfactory for a third-degree felony to get him back out there and give him the opportunity to be with his family, to work, and to be a productive member of society.
Right.
Thank you.
Mr. Lambert, Mr. Thornton, don't we have a bifurcated system in Texas so that first we establish there either has or has not been a violation of the terms of probation, and only if it's established or admitted that there has been a violation of the terms of probation do we proceed to a disposition hearing?
Yes, sir. Your deferred proceedings, deferred motions to adjudicate are bifurcated, and a motion to revoke is a unitary proceeding. So after you make a finding, then we have to have a trial and punishment in this case.
Apologies, Your Honor. I forgot it was a deferred. You're right.
All right, Mr. Thornton.
Your Honor, with regards to the allegations, we have a plea of true to 11, 14 B and D, 17, 24, 25. And you've heard evidence on number 1 that's based on a preponderance of the evidence that he is guilty of that offense or guilty of the allegations alleged, at least in the motion to revoke. With respect to number 6, not responding to the, or not informing the probation to testify, never been notified. And
all right, I've muted Mr. Arwijo just because of the noise in the background there at the jail. Mr. Thornton, if you would back up a little bit.
Sure. Let me go back to number 6. I had my 2 rules number. I mean, you heard probation state that he had never once provided them with employment information. In fact, to the contrary, didn't say he was working there, said that he just didn't have a job. Now he said that he did have a job with his dad. There's been no records introduced to show that. He said he got paid cash. Dad hasn't even come to confirm that here in court today. And the only testimony we have is to the contrary of that, which is he was unemployed, which is what he informed probation according to their notes. Rule number 11, with regard to reporting, he did not report. He did not show up his first date, was given a second chance, didn't report, and then chose not to attempt to follow up or reschedule after that at all, and didn't attempt to make his fees, and then testified that when the check was returned, he just gave up and didn't try to have it made out to anybody else or attempt to figure out a way around that or send a new check, because that was one payment. A payment had to be made every month. So even if that first one is forgiven, he continued to not attempt to make those. And if he did have a job and was paying child support and able to make his bills, as he said, then he would have been able to make those payments. So either one of those 2 things is not true. So, Your Honor, there's a ton of violations that he's either admitted true or has pled not true and has been proven here today. We'd ask the court to find that they're all true and let us proceed to punishment.
All right. I will, let me, hold on. Okay, I'll find that the defendant did violate rules 6, 11, 12, 14A, 14B and D. It didn't actually charge him with failing to make monthly payments. It says he failed to pay it. So I'm not going to find that's been proven. I'll find that the Rule 17 violation has been proven. On 24 and 25, the defendant testified that there were not classes available, and I don't recall that the probation office disputed that, so I will not find true on them. But I found true on the others. So do we want to proceed straight to sentencing? Is there a waiver of a pre-sentence investigation? Is there a request for a pre-sentence investigation?
Your Honor, I believe Mr. Arguello will waive it if you don't have any objections, and move straight to sentencing.
I have no objection.
Mr. Arguello, is that correct? That's what we spoke about?
Go ahead, sir. You were muted. We could not hear your response.
Yes, sir.
All right. Any further argument?
No, Your Honor. I believe I've made mine.
For sentencing, yes, I do have an argument for sentencing.
All right. Go ahead, Mr. Thornton.
And Your Honor, I would refer you, of course, all the evidence that was admitted in the first trial should apply to this punishment hearing. So we'd ask, if you haven't had a chance to read the offense report, if you take some time to do that. And you'll see that the facts of this offense is something, of course, we've got to take into consideration in punishment of this case. And that was actually a fairly violent and manipulative assault that he committed on his girlfriend at that time while she was driving a vehicle, putting them in danger. And we definitely think that that is something that needs to be taken into consideration. And this defendant pled guilty to that and continued basically to do nothing on probation. He reported a couple times and then never responded, didn't make an attempt to make up for that. And I understand COVID was going on and that there was difficulties, but it's his responsibility. And he has testified that you explained that to him. And he understood that it was his responsibility not just to make the payments, but to follow up with probation and to keep on top of all of this and to continue to stay in contact, which is rule number one. Most important thing to do is to stay in contact and to follow up. And none of those things were done. In fact, he continued to be in trouble in the law. He's been charged twice with criminal trespass, one which you heard evidence that somebody on probation, even if they're supposed to be there, they don't run into the house and hide in an attic. And when they do that, they're honest to this court about it, that they were hiding in the attic, and not lie to this court that they were up there trying to find something and the door closes behind them. So this is somebody who's been dishonest with the court, who has testified that he's been convicted of 2 felonies, one of which was a probation that he was revoked off of and sent to prison on. So he has shown that he hasn't been successful now twice. And he was given 9 months on that, which is less than half of that sentence. So this sentence, Your Honor, for assault of a family violence with previous conviction is up to a possibility of 10 years. And so since he was given a quarter of that sentence when he pled to, well, actually more than a quarter of that sentence when he pled to the 9 months of his first revocation, we think that a sentence of 5 years in the Texas Department of Criminal Justice is appropriate on this. And that's what we asked the court to sentence him to.
Mr. Lambert.
Thank you, Your Honor. And thank you, Mr. Thornton, for hearing us out and having this case today. The state is correct. He has had some violations. I don't think he's been given an opportunity to really fulfill his goal. I don't think putting him in jail for 10 years is going to be something that'll benefit Mr. Arguello. He has a family. He's got to man up and start taking care of that family. The allegations that he was lying to the court, we don't have any proof of that. He has a right to be in his house wherever he wants to be in his house, if that's in the attic, if that's in the basement, regardless. Now, it is stated that he has to contact the police or speak with the police if they come up and speak with him. I don't believe Mr. Officer Benegas stated that he called to him or said anything to him. He just drove by and stopped the car. So I don't think that was a lie on Mr. Arguello's part. We would request reinstatement of probation, adjudicated guilty, and for him to serve his sentence in probation.
Okay, we'll take this under advisement. I will make a ruling this week. I need to take off at this time. Right. And we will have to reconvene at some point. But again, I'm sorry, I just got a message. I have to take off and leave. So leave the hearing at this time. I'll get back in touch with the attorneys.
Thank you, Your Honor. Norma, can you put me in a breakout room real quick, and I'll call it a day too. Mr. Thornton, thank you today for being available.
I'm going to put you in breakout room number 6, Mr. Lambert.
Thank you so much, and we'll be quick and look out for an email for a reset date.
Okay, yes, sir.
Thank you, Norma. Thank you so much.
Yes, sir. Yes, sir.
Yeah.
Have a great evening.
You too.
Thanks. Bye-bye.